for filing written statement, my lord. It will well within the time of 120 days. Last quarter.
When you receive the writ of summons,
Yes, my lord. I have received May 29th.
affidavit is ready. Where is your affidavit? Where is your written statement?
My lord.
Grant time. You file today. Liberty is granted to submit the written statement in the department in course of the day, subject to.
I was seeking no leave to draw and complete the decree passed by Lord Lord on 24th July, my lord.
My lordship, to mention, the matter which is appearing is item number 91 in lordship's list. This was not fixed by my lord, not on 28th. Lord, 29th, Lord, it was not, your lordship had heard not the parties not in part, and Lord, this was fixed on 29th. Lord, on that day, Lord, for some reason, Lord, your lordship Lord could not sit, Lord, so the matter Lord was not taken up. So, Lord, if a date and time Lord could be fixed, Lord, for this.
91.
Yes, Lord, 91.
Before vacation.
I understand, Lord. So, Lord, could it be not marked parted, Lord, and Lord be listed, because it was lordship has recorded, Lord, that it is not that has been argued at length. Lord. Could it mark parted, Lord, and list fixed, Lord, for hearing after the vacation? It's already recorded in lordship, Lord, that substantially heard, Lord, heard at length.
कोई डेट है क्या बिफोर वेकेशन कोई डेट है हाँ देखो कोई डेट है
नहीं
25th कितना नहीं वो 12:30 है आंसर
No.
25th of September 25th September
very good
at 12:30
very good
inform the other side.
I'll inform the other side.
लिख लेना hello yes mention yes
my lord, I am praying leave to mention one matter, my lord, from the appellate side list, my lord. That was appearing as item number 187. This is about, my lord, a mental patient. The mother of the particular child is seeking custody, and as well as, my lord, the nominated representative of the Mental Health Care Act 2017, my lord. The application was made, and, my lord, as because there is a jurisdictional board, mental health board is not functioning in the city civil court. So that is the reason, my lord, I have prayed before your lordship to appoint the mother as the natural guardian, as well as to look after her, to do all the necessary things.
why the writ petition? Why you not gone for the Guardianship Act?
My lord, that is Mental Health Act.
Mental Health Act
1987 has already been repealed by the 2017 Act, my lord. I shall come up with the necessary, my lord, the acts and rules, as well as, my lord, the Mental Health Act, Health Act 1987, my lord, which was repealed.
But
my lord,
come on Thursday mention, because I have not filed, no staff is there. How I will take the note on that? Come on Thursday mention, we'll see to that.
my lord, then, my lord, Thursday I shall mention the matter, as because your lordship is taking this matter. Thursday I shall mention the matter upon notice, and if this can be taken up on Thursday itself, my lord.
How it can be? If you mention,
it's a urgent matter, my lord. The vacation is coming to close, my lord, and this is the last week, my lord.
So why you have
my lord, I
sit
have
tight over the matter so many years? When you filed the
years, this is 2025.
when you filed, which month you filed?
May, in the month of May it was filed, my lord. Matter has been mentioned in several occasions, my lord. Thereafter the matter was bifurcated before your lordship.
My bifurcation of in my list, that is after 580 matters.
Yes.
580 matters. Then you're not, why you're not mentioned before the regular court before that?
Regular court it was mentioned, my lord. It is not that I have not mentioned, I have not tried, my lord. I have mentioned in several occasions. But there are the tender matters, other group 9 matters, my lord.
That is your mentioning list. Where is the mentioning list?
Yes, my lord, that is here.
इसको ले लो
Yes.
और 10 आइटम के बीच में नहीं रखते. Inform the other side.
Milord, may I be permitted to mention item number 31 of today's list, Milord?
Senior is mentioning. Let complete.
Sorry, Milord.
Milord, may I be permitted to mention this matter, my lord? Your lordship has been pleased to direct the official liquidator to file a report in respect of, my lord, property of the company in liquidation being occupied by certain occupiers
Hmm.
and paying a very paltry rent, my lord. My only prayer, my lord, today is before your lordship, my lord, if it could only be clarified, subject to your lordship being satisfied, that let the official liquidator also have the liberty to take steps to evict these occupiers in the meanwhile.
That's why now I appreciate you all on the last occasion.
Yes, yes,
you
lordship
mentioned that,
remembers.
but I have not mentioned. Let this come and I will see to that.
Only thing is we'll lose about 1.5 months. That was my only concern, but I leave it to your lordship.
October, let it come in. Because during puja nobody
Very
will
well,
do
my
it.
lord. Great.
Yes.
My lord, may I be permitted to mention item number 31 of today's list, my lord? My lord, in that matter, my lord, two applications are there, my lord. One is under Order 7, Rule 11, and one is Order 12, Rule 6 application. Both application has been heard, my lord, at length, my lord. Only one defendant has also completed his submission. Plaintiff has also completed his submission. Only one part is remaining, my lord. That defendant want to show a judgment, my lord, whether at the time of hearing an application under Order 7, Rule 11, documents of the plaintiff can be looked into or not. Only that part is remaining, my lord. I'm praying, my lord, some precedence can be given, my lord.
Will come today. The new motion is up now. Tomorrow the adjourn motion will come and you will get the chance. It is in the list. Let you come and see what will happen. Yes, call
Some
on it.
precedence, my lord. My lord, I've already heard the matter at length, my lord.
No, but it is adjourn motion within 10 matters. Let come tomorrow the adjourn motion and it will see to that.
Or else, my lord, if that can be part heard, my lord, subject to what falls from your lordship.
Right to be
My
made.
lord, item number 1, my lord, I appear for the petitioner, my lord. I am the defendant in the suit, my lord.
For the petitioner, my lord.
Yes.
My lord, I am the defendant in the suit, my lord. My lord, this is an application which has been filed by me. My lord, it's a demerer application, my lord. I indicate what this is. This is essentially, my lord, an application seeking the enforcement of a specific forum selection clause which vests jurisdiction exclusively with the courts in France. My lord, I had the occasion to argue this before my lord on a few occasions, my lord. My lord had heard us substantially as well. My lord, then the determination changed. And my lord, the matter wasn't really heard because my lord, what had happened, I'll indicate, my lord, was that there were some papers which were missing. My lord, pursuant to the order of the coordinate bench, the records have been reconstructed. My lord, the matter is ready for hearing, and since my lord had heard it earlier, I was praying my lord would my lord, if permits, any date subject to my lord's convenience for us to resume our arguments before my lord.
Right, let it come in the list because before vacation it is not possible to.
Any day subject to my lord's convenience, this side, that side of the vacation, any day. My lord, just one prayer which we had, my lord, would kindly consider, my lord. I understand that perhaps it will not be possible before the vacation, but my lord would kindly consider one prayer, my lord. My lord would kindly take the order dated 27th of February 2024 passed by my lord. My lord.
February 24.
My lord. My lord would kindly see, my lord, that my lord had heard us substantially.
Maybe the no order is there. Okay, let it come.
My lord would kindly consider marking it as part heard, my lord.
Let the matter come on adjourn motion tomorrow. We'll see to that.
But my lord would kindly consider, my lord, as if my lord considers part heard, my lord, we would be grateful, my lord.
I am not keeping any matter part heard.
Grateful, my lord. Grateful. Grateful.
It is submitted by the Learned Council. You are appearing?
Yes, my lord. Let me show it.
Learned Council for the apprentice submit that the matter is related to forum selection clause.
My lord, I am for the defendant, my lord. I am the petitioner, the defendant, number 1.
That the defendant has filed an application taking the advantage of the forum selection clause in the agreement, and this court has heard the matter at length on the earlier occasions, and such he prays for fixing the matter for hearing. In view of the submission made by the counsel for the defendant, let the matter appear in the list under the heading adjourn motion tomorrow.
Grateful, my lord. Grateful. Grateful.
One thing, when a lordship may expedite the suit, this application may be heard by your lordship.
Let come, then I am not passing it. Let it come at adjourn motion, then I will hear it. Then
With the business of your lordship, it would not be possible.
what all persons are telling that in Prated, how it can be, then this could continue with that.
My lord would kindly consider, my lord, as part heard, my lord. My lord had heard it, which is why the prayer, my lord. I'm sure my learned friend will not have an objection to that.
Your friend is given the option that let the matter should be expedited so the matter can be disposed of.
My lord, we will not take too much time, my lord. It's a very short point, my lord had heard, which is why.
Be expedited, not the application. Not the application.
My lord, how can that happen, my lord?
Das Gupta is of the view the suit is to be expedited, not the application.
My lord, we've argued substantially. My lord has to decide. My lord.
Let the matter come as adjournment.
Grateful, my lord. Grateful to my lord.
The date and time, any time, my lord, any day, November, December, any day. Because
My lord, that would also be very, my lord, if my lord kindly does that also. Any date.
Then I can fix a matter in the month of December as a special fixed matter.
But my lord would kindly consider the part heard part, my lord. It's a prayer, my lord, from, I mean, both of us, I believe, will have the same prayer, my lord. Kindly consider, my lord. It's a prayer, my lord.
You are the fourth person now mourning the part that you are.
My lord, because my lord would note that my lord had heard our arguments substantially, my lord, would kindly consider, my lord.
If the determination change, if you find that the substantial heard, then you made an application, you know the process.
My lord would kindly consider.
December, my lord.
Okay, yeah, okay then. As per the submission made by the counsel for the respective parties, let the matter appear on 22nd December at 3 p.m.
My lord, 22nd, my lord, makes it
3 p.m. As is
very well, my lord. Grateful, my lord. Grateful to my lord.
Yes, call the list.
My lord, item number 2, I'm for defendant numbers 11 and 12, my lord.
I am appearing for the petitioner in this
I'm
matter.
for the 2, 3, 1.
I appear for the plaintiff.
I'm appearing for
This order only I passed with regard to the defendant number 6 and 7, and I have vacated the interim order passed by this.
It's your matter.
I dispose of the interim application with regard to the defendant number 6 and 7, and I have vacated the interim order.
My lord, only one thing, my lord, there's the interim order is subsisting, my lord, till 24th.
Yes.
My lord, if your lordship kindly considers extending it.
My lord, if I may, my lord, by an order dated 2nd September 2025, my lord, the interim order was lastly extended till 24th September.
24th September, the matter will be taken up from. It will be in the list. It will be in the list because there is an order.
Correct.
List on 24. Let's come on 24.
My lord, I'm appearing for defendant number 8 and 9. May I file my affidavit?
Come on 24. Come on 24.
My lord, so far as I'm for the so far as the order dated July 31st, 25 is concerned, my lord was pleased to call for the written statement filed by my client.
Okay, let's come on
24, my lord.
I will see because
Lordship.
today only with regard to the order. Of
I'm
the
grateful, my lord. I'm grateful.
Come on.
My, that was still pending since
Yes,
long
I will
time.
record submission of all the advocates with regard to.
Lordship, grateful.
I am tendering
Grateful, my lord.
one matter for leave lordship. Yesterday also I have mentioned lordship, but your lordship not allowed. The agreement was done in between the plaintiff and the defendant for construction work lordship. The defendant, without allowing the plaintiff lordship, engaged another any third party lordship due to the agreement lordship to do the construction work. For postponing the construction work, lordship, this is very urgent lordship, but performance of contractor lordship. I am saying leave to move the matter lordship on 18th or 19th. That your lordship.
Why? Where is your main suit?
Lordship main suit. It is within the original side jurisdiction of this high
No,
court.
it is
The suit value is more than 1 crore.
if you file a new suit or if you want to file an application for
Lordship, new suit with injunction petition, lordship.
new suit.
Yes, lordship.
Give what is that?
Lordship.
So why the leave is required? You go and file in the department.
Lordship, but the matter to be fixed, lordship, then I have to serve the notice to the other side also, lordship. Within that time, lordship, the matter to be heard, lordship, as your lordship's convenient date, lordship, on 18th or 19th September, lordship. Neither the construction work, if completed, lordship, my application will be in future, lordship.
No, this is a commercial suit.
Yes, lordship.
Where is the 12A non-starter report?
Let's say I have to annex with it.
Where is the non-starter report?
Let's say as per the
Not approach the pre-institution mediation.
not means
Then how the suit is maintainable? Then it will be dismissed.
no, lordship. It is within the suit value is more than 1 crore and 70 lakhs.
I appreciate suit value, parties, commercial agreement, mercantile, all I appreciate. Only I want to see whether you have initiated the pre-institution mediation under Section 12A of the Commercial Code Act.
Lordship, I sent the notice to the defendant, Lordship. No time, Lordship. If the construction work is done, Lordship,
I
then
where is the pre-mediation the non-starter report?
Lordship, as the construction work is started, Lordship, I found that the construction work is started going on, Lordship. Therefore, immediately I have to file this application, Lordship. There was no such provision for filing of the mediation before the.
No such provision.
Yes, in as per the agreement, Lordship, and the suit value is more than 1 crore.
You are having the Commercial Court Act. You are having
not now, Lordship.
Give it to a left. Read 12A. Section 12A.
A suit which does not contemplate any urgent interim relief does not contemplate any urgent relief, Lordship. Under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner. Lordship, there is the provision not urgent, any urgent, but this is very urgent.
Urgent. The urgent what is to be done? If you are having urgency, then what is to be done?
Procedure as may be prescribed by rules made by the central government. The central government may by notification authorize the authorities constituted under the Legal Services Authorities Act such and such for the purposes of pre-institution mediation. Lordship, if the matter is not so urgent, but it is very urgent, Lordship, if the construction work is done and completed, my agreement will fail, Lordship. I have no such reason for coming before this honorable court for specific performance of contract, Lordship. I am instituting this suit for constitution of the specific performance of that agreement, Lordship.
Specific performance of contract what?
Lordship, as the construction was as
construction of
construction work in the premises of the defendant number.
So where it is come under the purview of the commercial court?
As the pecuniary jurisdiction is more than 1 crore and 70 lakhs, yes, Lordship. The city civil court having the jurisdiction up to 1 crore, Lordship. Above that, the high court.
Please, you go consult with your senior and come tomorrow. Consult with the senior.
এখন এটা যদি আর্জেন্ট না হয় কিন্তু এখানে তো আমার খুবই আর্জেন্ট রয়েছে।
Please go to the senior, consult with the senior. Yes, call the matter.
Lordship, I am appearing on behalf of the plaintiff.
Yes.
Lordship, it was this matter where Lordship had directed the advocate who was appearing to have a conference with the seniors of Calcutta. Lordship, there were a lot of defects in the suit, and in some of the work orders, Lordship, there is an arbitration clause. In such circumstances, Your Lordship, today I am seeking the leave to withdraw the suit with the liberty to file afresh.
File afresh or go to the arbitration?
There's some work orders without an arbitration clause, and some have.
So some will be for this court and some will be arbitrator. It is the law. What has happened to all of you?
I wish we have instructions to withdraw for.
The counsel for the plaintiff submits that after going through the pleadings, the plaintiff found that there are several technical defects in the plaints, and as such, the plaintiff intend to withdraw the suit with the liberty to file afresh. In view of the submission made by the counsel for the plaintiff is allowed to withdraw the suit, liberty to file afresh. Full stop. Yes, full stop. The court fee, as the suit has not been admitted and the plaintiff is not been admitted, according department is directed to refund the court fee, and the plaintiff has liberty to use the said court fee if the plaintiff intend to file a fresh suit in future.
Deeply obliged, Your Lordship.
Obliged, Your Lordship.
Yes, comes this has withdrawn with the liberty to file.
Your Lordship, I'm led by Senior Advocate Mr. Devajyoti Basu. He is on legs before.
Which one? Which matter? 10?
10. I'm
Yes.
appearing for the plaintiff.
You are appearing for?
Plaintiff.
Ah.
I am led by Senior Advocate Mr. Devajyoti Basu. He is on legs before a different court. I'm playing for a short pass over, Your Lordship.
Who is for the defendant? Pass over.
Grateful, Your Lordship.
Item 11, I appear for the plaintiff, my lord. On the last occasion, my lord had inquired whether any amount has been deposited with the registrar or not. My lord, I have received a copy of a forwarding letter. I'm forwarding this. Lord, they have intimated us that no amount has been deposited. We were arguing, I was being led by Mr. Atul Das. We were arguing GA2. That arguments were made. We have now come up with a written notes of the defendant is not appearing. But if the written note may be taken.
ये order sheet को
Original I'm carrying.
Yes.
My lord, if my lord kindly takes the written note once.
Hmm.
My lord, GA1 was our application for security, my lord. That was allowed. Interim order is continuing in that. In opposition to GA1, the defendant had admitted an amount of 32 lakhs. That is in the pleadings, my lord. GA2 is for judgment upon admission, my lord. They have stopped appearing. They have not filed any objection to the same. So, my lord, that amount be secured kindly. After the passing of the injunction order, we had written to the Standard Chartered Bank. They have intimated to us that an amount of 30 odd lakhs rupees is lying in the bank. That is there, my lord. That amount be kindly secured. So we are paying an order in terms of GA2, my lord, prayers in GA2.
Judgment and decreeing and GA2.
GA2, my lord.
GA2 judgment upon admission.
Judgment upon admission.
Huh.
In judgment upon admission, we have annexed the opposition file to GA1, my lord. In opposition to GA1, the defendant has admitted an amount of, my lord, if kindly, I'll show you the, my lord, page number. If my lord kindly takes page 162 of GA2, it is in volume 2.
$162.
This one.
Yes.
Paragraph 13, my lord, that with regard to the statements made in para 20, I submit that since 2020, I have been suffering financial crunch and no option to repay by bank loan, financial institution depending on the said customs refund to resettle the business and return back the dues. Now, my lord, kindly takes page. Page 163, top, my lord. I have no intention to commit or cheat or fraud upon the petitioner. Herein, I shall definitely refund the outstanding amount of rupees 30 lakhs.
Page.
163 top, my lord. It continues from 162. 163 at the top, my lord. The outstanding amount of rupees 30 lakhs 32,055 upon release of the custom security deposit, which he is entitled to. In terms of this admission, I'm paying up for an judgment upon admission, and GA2 is for that, my lord. I have filed my note. The prayers are at page 22, my lord.
page?
22.
22 of GF2.
GF2, volume 1.
Which prayer?
Well, the entire dues were to the tune of rupees 80 lakhs in their objection to GF.
22 is the plaint, na? It is a prayer in the J1.
Well, GA2 volume 1, I believe.
GA2 volume 1, page 22.
Yes, well, it is the
22 is that is prayer in connection with GA1.
GA1.
So you are arguing the GA2 and asking for the prayer of GA1.
No, my lord.
Then
in that event, my lord, kindly gives me a short pass when I'm meeting less by Mr. Das. If he may come and
next.
Led by
My lord, I appear for the respondents, my lord, in these applications, my lord. GA3 is my application. I am the petitioner in GA3, my lord. My lord, this is an application by the respondents number, defendants number 2 and 3 in the suit, saying that their name should be struck off from the array of parties, my lord, because they only happen to be directors of the company, which is defendant number 1. When an affidavit in opposition was sought for, my lord, they have filed their opposition only recently, my lord. I intend to file a reply to this similar opposition that they have filed in GA number 3. GA number 4 is a new application filed by them, my lord. I would also intend to file a reply in GA number 4, my lord.
Where the GA4 is there?
Yes, is their application. So AR in GA3
has filed affidavit in opposition in connection with GA.com 3 of 2025. After serving copy to the Learned Counsel for the defendant number 2 and 3.
Yes, my lord. Yes, my lord.
Let the same be quickly corrected. The plaintiff has filed another application with Form 4 of 2025, praying for summary judgment. What?
Yes, yes, my lord.
For summary judgment. For the defendant number 2 and 3. You are appearing for all or 2 and 3?
All of them, my lord. All of them.
Defendants press for time. Affidavit in reply in connection with GA3 and GA.com 3 of 2025 within a week after preservation. Affidavit in opposition in connection with GA4 be filed within 2 weeks after preservation. Reply, if any, there to be filed within weeks thereafter. These both applications in GA.com 3 of 2025, Form 4 of 2025 on 27th November 2025.
Very well. I'm deeply obliged.
There is a formal defect in all of the documents that are filed by them. But if my lord comes to the written statement or the affidavit affirmed by Mr. Manish Kumar Karn on the 16th day of June 2020. My lord, both of the documents, amongst others, show that there are only 2 defendants. One rooted and one the coffee name of the third defendant in the cost title. The documents that they have filed.
But
you mention only name of the
I'll have to check this, Millard. I don't have a copy of the plaint with me immediately, Millard. Let him take his point in the opposition, Millard.
Well, in that case, the WS.
Come on, yes.
Yes, Millard. I'll have to check, Millard. I'm deeply obliged.
Call the next.
But I appear for the, my lord, I beg to appear virtually, my lord, with your lordship's permission, my lord. I appear for the defendant in this matter, my lord. My GA is on board today, my lord, for acceptance of written statement.
Lord, we had already will remember where the affidavit in support of master summons was affirmed within 120 days and master summons taken out post, written statement never filed. Even as on date, the written statement has not been filed after expiry of 120 days. I had cited my lord's judgment in Fox Mandal, my lord. That's there. I had also handed over a copy to my learned senior friend. That's the only point involved, my lord.
But may I be permitted to respond, my lord? Yes. It was my application. Mr. Mukhopadhyay had taken an objection, my lord, that the written statement was not filed. My lord, of course, the written statement will not be filed, my lord, because unless and until your lordship grants me leave, because it's beyond 120 days, my lord, I'll not be in a position to file the written statement. Now, my lord, my lord, may I just indicate 4 dates, my lord, for your lordship's convenience. My lord, on 28th of June 2024, the plaint was presented. Writ of summons was issued. Lord, will kindly note the date. Lord, 28th of June 2024. The writ of summons was issued on 24th of July 2024.
28th of June 2024. Plaint present.
24. The plaint was present. Yes. The writ of summons was issued on 24th of July 2024.
Yes.
The 30 days expired on 23rd of August 2024. And the period of 120.
When you receive the writ of summons?
24th of July 2024.
You received?
I received it.
Yes.
30 days thereafter, my lord, expired on 23rd of August 2024.
Correct.
And the period of 120 days, my lord, expired on 21st of November 2024.
21st November
2024. Now, my lord, before I take your lordships, my lord, through the reasons, my lord, I have to satisfy your lordships that there was sufficient cause for me to not file the written statement. But before that, my lord, may I just indicate, my lord, 2 documents. Lord, your lordships will kindly consider.
Any document, whether before 21st of November 2024, have you filed the written statement?
Yes, my lord, I'll just indicate, my lord, the application, which is before your lordship, was affirmed on 21st of November 2024. Along with the application, my lord, I had annexed the plaint, which forms part of my application, which was also, my lord, affirmed on 21st of November 2024. Lord, this your lordships will find at, Lord, will kindly takes the application, my lord, at page 12 of my application. Lord, will kindly seize the date, my lord, the affirmation of this application, 21st of November 2024. My lord, thereafter, my lord, right at the next page is the plaint which has been annexed along with this said application. At page 13, your lordships will also see the affirmation, the date of affirmation on 21st of November 2024. So, my lord, in essence, my lord, my submission would be, and I would like to, my lord, persuade your lordships, my lord, that here, as on before 128th day, my lord, the written statement was on record. The written statement was on record along with the application, which was also on record. Because your lordship is aware, my lord, this application is in form of, my lord, master summons. The master summons have to be supported by an affidavit. My lord, that's a prerequisite. My lord, affidavit is a prerequisite. The affirmation of the affidavit is also on the prerequisite, my lord, before I can even file this application. Now, this I will, my lord, enumerate, my lord, from 2 rules I'll rely upon. If your lordship will kindly takes up the original side rules. Lord, will kindly takes chapter 6 of the original side rules.
Yes.
Lord, may I read out rule 3?
Yes.
Mode of proceedings in chamber. The mode of proceedings in chamber on any application which may be made ex parte shall, except where otherwise ordered or prescribed, be by a petition, and where notice is required to be given, shall, unless otherwise ordered or prescribed, be by way of summons. Such summons shall be prepared by the party obtaining it or by his advocate acting on the original side, and be signed by the registrar or master. Where affidavit are intended to be used, notice thereof shall be endorsed on the summons. Lord, will immediately take, my lord, rule 4.
Yes.
With the summons shall be supplied a copy of every affidavit mentioned in the notice endorsed thereon, except of affidavit so mentioned used in former proceedings in this court in the same suit or manner. Lord, these two rules would indicate, my lord, that an application where a master summons have to be taken out, my lord, have to be supported by an affidavit. Now, the first step before I can file an application, my lord, is the requirement or the prerequisite of affirmation of this affidavit, my lord, before the registrar original side. This, your lordships will find from chapter 15. Lord, may I refer to chapter 15 of the original side rules?
First you say what is your contention. As per your submission, on 12th of November, you have affirmed the application, and as per your submission, on 21st of November, you have affirmed the written statement. So what
But
you
my,
making
yes,
the and what is the contention?
But my contention is, my lord, the date of the affirmation of this application, my lord, would be, my lord, construed to be the date of filing. And what is important, my lord, that as on that particular date, along with the application, the written statement was also on record. That was also annexed along with the application, affirmed on the same date. And the why affirmation is important, my lord, will also, my lord, I would have read out chapter 15, my lord, which says chapter 15, rule 5. If your lordship takes up once, my lord, chapter 15.
Yes.
My lord, rule 5. Affidavits taken before authorized commissioner, affidavits for use in any of the jurisdiction of the court may be taken in Calcutta, therefore before a commissioner generally or specially authorized by the Chief Justice for that purpose. Every such commissioner shall express in the jurat the place where he has taken the affidavit in the event of the same being taken elsewhere in the courthouse. My lord, this would indicate, my lord, that the affidavit, my lord, has to be first, my lord, before I can even file the application, the affidavit has to be affirmed. Thereafter, my lord, I can have to file the application, my lord, and thereafter the number will be generated. Now, in my case, what is
what affidavit, what application contain not no affidavit?
But it contains, but as a matter of first course, my lord, I have to affirm the affidavit. My lord, thereafter, my lord, I can
affirmation. What is the further course of action?
My lord, post affirmation, my lord, thereafter, my lord, it has to be presented for scrutiny.
Satisfied this court, you have affirmed the affidavit on 21st of November 2024. Yes. Correct?
Yes,
but why you have filed the affidavit on filed the application on 29th of April November 2024?
Here, my lord, here there was a genuine reason. My lord, your lordships, my lord, will appreciate, my lord, the situation was that, my lord, although I should not make this statement at the bar, but there was a dispute with the former advocate on record. There has been a change. But it's a change brief. This application was filed at the hands of the previous advocate on record. A new advocate on record is now on board, my lord, to pursue this application and in this matter, my lord. And my lord, I will rely on decisions also, my lord. I'm carrying decisions of this honorable court, my lord. Your lordship's decision also, my lord, where similar situation was considered and thereafter, my lord, orders were passed, my lord. But my contention is, my lord, your lordships will see the date of filing was on 29th of November, 2020.
Who is your advocate on record?
My lord, presently, my lord, is Mr. Shadnik Basu.
When she filed an affidavit, wakalatnama?
Lord, post this particular date, my lord, I do not have the exact date. My advocate on record is there. She'll be able to indicate. It was filed, my lord, post this particular date.
Whether she filed wakalatnama before 21st or 21st or after 21st?
Well, after, much after, my lord, much after 29th of November, my lord. Much after 29th of November.
Earlier, my lord. Yes.
Lord, now, my lord, in support of my contention, my lord, may I first, my lord, rely upon a decision passed by the coordinate bench. My lord will kindly considers, my lord, Prathishta Commercial, it's an unreported order, my lord, by the coordinate bench. Prathishta Commercial Private Limited versus Odisha State Cooperative Milk Producers Federation Limited.
Yes.
Yes. My lord will kindly takes up, my lord, page 3, the third paragraph, my lord, the 7th line. Page 3, third paragraph, the 7th line, it starts with Writ of summons is on 18 January 2023. As indicated in the mode of service, the 120th day expired on 18th of May 2023. The period of 120 days from 3rd February 2023 has not elapsed. The defendant has verified and affirmed a written statement on 18th May 2023, that is within 120th day from the date of receipt of the writ of summons, if it is taken to be on 18th of January 2023. In view thereof, the written statement affirmed by the defendant on 18th May 2023 is allowed to be filed in the department without prejudice to the rights and contention, my lord. In this order also, my lord, the date of affirmation was to be, my lord, was taken into consideration while allowing the written statement to be filed. The application also, my lord, in this particular order was filed, my lord, beyond the period of 120th day. My lord, the next, my lord, your lordship's order, my lord, in Roman Catholic of Calcutta versus Creative Consultation. Lord, may I be permitted to place that order?
Yes.
But this is slightly against us, but here also, my lord, I'll indicate your lordships have held otherwise because of a specific facts and circumstances which was also there in the Fox and Mundell case, which my learned friend has relied upon. But I'll read from paragraph 4 of the judgment at page 1.
Yes.
But my lord, will kindly cease. Counsel for the plaintiff submits that the plaintiffs have received the writ of summons on 22nd April 2024. And after receipt of the writ of summons, the defendant has authorized one of the partners to look after the case by way of a resolution. Thereafter, the defendant has contacted the learned advocate for taking appropriate steps. In the first week of May 2024, the advocate for the defendant has directed to bring all the documents to draft the written statement. My lord, page 2, may I read from paragraph 2? Lord, third line, accordingly, the learned advocate has prepared the written statement and has taken leave from this court on 14th August to affirm the written statement. Accordingly, on 14th August, that is 120th day, the written statement was affirmed. Subsequently, the applicant has filed the present application on 30th of August 2024. My lord, beyond 120th day also in this matter, the application was filed. A similar contention which I am now raising was also raised by the defendant in that particular case, and thereafter, my lord, your lordships will kindly consider page 3, my lord, the second last paragraph. Your lordships have considered Pratishtha Commercial, lordships have considered the Fox and Mundell decision, and thereafter your lordships have observed. Counsel for the plaintiff submits that even after taking into consideration, the defendant has affirmed and verified the written statement on 14th of August 2024, but has not filed the written statement. And the written statement, my lord, will kindly note, this is a very important distinguishing factor. And the written statement is not on record of this court. And he prays for dismissal of the application. My lord, along with the application, in this particular case, my lord, the written statement was not on record. Now, my lord, an appeal was preferred by the defendant in the facts and circumstances of this case. My lord, will also consider page 4. My lord, I apologize, my lord, I should have also pointed out page 4. My lord, just above SCG contracts.
Yes.
Now, the paragraph above, my lord, the third line, admittedly, in the present case, the written statement was not taken on record. It was found that though the defendant has filed the present application on 30th August praying for condonation, the delay and the acceptance of the written statement, but in the said application also, my lord, will kindly note this, the said application also, the defendant has not enclosed the copy of the written statement so that this court can presume that the written statement was on record. Lord, in fact, this observation also, my lord, goes in my favor because I'm also making a similar contention and plea that in my case also the written statement was on record. Now, an appeal was preferred, my lord, against this order by the defendant. My lord, may I place the appeal court's order? Lord, may I request the advocate on record to please hand over the appeal court's order? My lord.
Yes, yes, continue.
Yes, my lord, will kindly seize, my lord, 4th December 2024.
Yes.
My lord, a division bench order, my lord, page 2.
Yes, I know that this 50,000 rupees cost was imposed.
Yes,
And,
my lord,
and
yes, my lord,
given
here,
consent, kindly come to the paragraph, given the consent.
yes, lord will kindly
For the appeal,
considers, my lord, here
defendant has
also.
given the consent. The court has allowed written
Yes,
statement.
the defendant has given consent, my lord, but
For the
in
appellate
effect,
authority, that's why the appellate court has granted 50,000 rupees cost. Yes, next.
my lord, even otherwise, my lord, the appeal court has also made an observation, my lord, which I just wanted to point out, that in all the cases which has been cited by the other side, my lord, in all those cases, the written statement was not prepared within 128
Two
days.
question you give reply to me.
Yes.
Under which provisions of law you all advocates, I am telling to the total bar, when the application has been affirmed before the commissioner, how you are taking back from in your hand? Once you affirm the affidavit before the commissioner, it has become a court record. So how you have taken the back and you filed on 29th? First thing. Second thing, if you are affirm the written statement on 21st, why you have not taken the leave? Because there is a circular by the bar on the instigation of this court. If any persons intend to file the written statement after the 30th period and within the 120 days, take leave from this court, and this court is allowing on each and every advocate to submit the written statement. And why you are not? You are not a member of the bar. You are not aware of the circular issued by the all the three bar association.
And may I respectfully make this submission, my lord? My lord, insofar as this case is concerned, my lord, the advocate on record.
And you are telling that your advocate on record had come in January 29. How you have filed this? If your advocate, earlier advocate on record has not filed on 21st.
But this
You have given
affirmation.
the allegation on the earlier advocate on record, and your advocate on record has come in January, and you filed in November. Who has filed this application?
Let me respond, my lord, with your lordship's permission.
Kindly see the, your application on 19th, the Wakalatnama was filed. 11 September. 11 September
the
is
application,
the Wakalatnama was filed.
the application was filed
to file the affidavit on 21st.
To that extent, my lord, it should have been, my lord. In fact, all written statements should be filed within 128 days. There's an outer limit, my lord. We cannot, my lord, ignore the provisions of law, my lord. It cannot be ignored. It's a mandatory provision. It had to be filed within 128 days. My lord, secondly, my lord, there has been no allegation, at least from our side, regarding the advocate on record. But there wasn't conflict because of which there is a change. My lord, I mentioned the word conflict because of which there has now been a change in the advocate on record. My lord, that was my humble submission before your lordship, my lord. And the reason why I cited, my lord, the division bench's order, my lord, your lordship is aware, my lord. I am aware, my lord. But only to the extent that there also, my lord, the division bench, my lord, considered the situation of the defendant by making an observation that in all the cases where the written statement was not allowed to be accepted, my lord, those written statements were prepared beyond 128 days. My lord, my honest intention was to indicate that here the written statement was ready. It was, my lord, presented, my lord, it was ready to be filed. That's why it was affirmed within the 128 days. The affirmation was also done, my lord, to the best of my knowledge. It was done, my lord, after obtaining, my lord, mentioning the matter and obtaining a lordship's leave. My lord. My lord, I'm not multiplying, my lord, judgments. There is another, my lord, coordinate bench's order, my lord, of Justice Arindam Mukherjee on the same point, that where, my lord, on the date of affirmation, my lord, the written statement was accepted. Now, my lord, I will explain.
Affirm the written statement on 120th, 119th, keep with your in your file, tag with your file, and come after 3 years. Please see, I have affirmed the affidavit on 119th days or 118 days or 45 days. Please accept after 3 years.
Lord, will kindly, Lord, permit me to, madam, just
and you
make
will,
one.
And you will take them. Yes, my advocate on record, earlier advocate on record, sir, kept the written statement in file.
That was not our submission, my lord, and we cannot also again, my lord, I'm repeating my submission that it's a mandatory provision of law. We cannot ignore the basic provisions of law. But your lordships will kindly consider that there was a delay of 7 days in filing the application. Just 7 days, 29th of November, the application was filed. And so far as the reason, my lord, there was a genuine reason also why there was a delay in filing of the written statement. The plaintiffs in the present case, my lord, had filed an application. My lord, an application, my lord, praying for an order of security. My lord, your lordships allowed that application direct, my lord, injuncted the bank account of the defendant, my lord, asking them to, my lord, deposit a sum of rupees 40 lakhs, my lord. Against that order, we had preferred an appeal, my lord, because our bank account was injuncted. There was a standstill in the operation of the defendant, my lord. I've mentioned everything. All the pleadings, my lord, are there in my application. We have preferred an appeal also. Even the division bench, my lord, upheld your lordship's order, my lord. A substantial time was, my lord, lost, my lord, because of this parallel litigation which was going on in connection with the same subject matter, my lord, because of which, my lord, this said written statement, though was prepared, my lord, could not be filed within time, my lord.
Will allow my.
Two things. Affirmation and filing are two different things. Affirmation before the commissioner of oath, the role of the commissioner of oath under the original side rules is limited to putting the deponent on oath, nothing more. It does not make the document a part of court record. The document becomes part of court record only when it is filed with the central filing. Number one. Number two, the affidavit in support of the master summons is not the application. The application is the master summons under the original side rules. The master summons in this case has been taken out on 26th of November. The affidavit is the grounds for the relief sought. So effectively, the application for extension of time to file written statement was taken out on 26th November, not 21st November. Number one.
26th number, where you
26th November, kindly see the master summons, well, the date when the summons have been issued. That is the application.
Yes, yes.
The affidavit is not the application. GA2 master summons.
Hmm.
Kindly see, the master has signed the application and taken it out on 26th of November. Second page, the master's signature appears. Page 3.
Yes.
So as of 26th of November, the application is born for the first time on 26th of November when the master signs on the summons and issues the summons on the basis of the grounds which is the affidavit. So the affidavit may have been sworn. It is like saying if the party is in Delhi and affirms an affidavit and written statement in Delhi on the 21st, that does not make the application part of court record on the 21st. So this became a part of the court record only on the 29th when it was served and then filed in the central filings department.
Correct.
So as on 21st November, there was no application or no written statement as part of the court record either by way of this application or its annexure.
Yes.
So that is the first fallacy in the argument of my learned friend. All the judgments that he has shown are distinguishable on the primary ground that before 29th of November, neither this application nor its annexure, the written statement, was a part of court record. Number one. Number two, my lord. Number two, my learned friend made a statement, but I think he is not correctly instructed. This matter was never mentioned on the 21st for leave to file written statement. Thirdly, let us take the judgments that he has cited. So far as the appeal court judgment, my lord, apart from the issue of consent, whether any appeal lies against an order from an order rejecting leave to file written statement is in itself a question that has to be answered in the negative. The Commercial Courts Act clearly limits the classes of orders against which appeals can be filed. There is the judgment of Justice Nariman in Kandla Port Authority, which clearly says that any order that is not appealable specifically under the Commercial Courts Act cannot be appealed from any appeal filed, entertained. It's all a nullity because it's completely contrary to the statute. That's number two. Number three, my lord, the situation here was that the written statement was ready. It was mentioned. The plaintiff's advocate said that I don't have any objection, but I can't be present for mentioning. Thereafter, the matter was mentioned 2 days later, which was again within 120 days. And the court said you take out an application. Now put that fact situation to the fact situation in hand. It is completely different. Thirdly, Justice Mukherjee's judgment also, my lord, will find that this is decided on 19th May after the written statement was affirmed on 18th and must have been mentioned for
Taken
filing.
on record, yes.
And that this is not a final order. It's just taken on record subject to something else happening in the Order 7 Rule 11 application. So, my lord, with deepest of respect, as unfortunate as it may be, my lord, this defendant has lost the bus, missed the bus, my lord. Okay.
Lord, with your lordship's permission, I would have just, my lord, cited, my lord, two more authorities. Just, my lord, I'll just cite it. My lord, I'll just request my learned friend to hand over, my lord, an extract from Words and Phrases and an extract, my lord, from Stroud's dictionary, my lord, just on the interpretation of filing, my lord. You kindly permit me to, my lord.
Yes.
My lord, your lordships will seize the extracts from Words and Phrases. My lord, the meaning of file.
Yes.
Lord, the word filing in reference to matters of practice is very commonly used to express the duty of bringing to the proper office, as the case may be, writs, pleadings, affidavits, and any other matters for safe custody or enrollment. Lord, this is again, my lord, in furtherance to my submission that the fact that I had brought the affidavit on record, which is a prerequisite for me, my lord, to take out the summons, my lord, is a fact, my lord, that this was on record before the court.
If you are aware that the master summon is to be supported by an affidavit, so why you not file all the both on the same day? Why you waited for the another 7 days?
Lord, in my respectful submission.
There is no rule that you first go and affirm the affidavit, then you come with the master summon.
Lord, the affidavit has to be, my lord, first. It has to be first affirmed. Lord, the affidavit has to be first affirmed.
You have
Lord,
to prepare both and affirm and file in the department. The department, it is not your case. You went to the department on 21st and the department has not accepted your application. Come with after 1 week or whatever it is. That is not your case.
My lord, your lordships.
What is the justification for not filing the application on 21st?
Your lordship is aware, my lord, that there are, pursuant to, my lord, affirmation of the affidavits, my lord, there are further formalities, my lord, which are required to be taken up before.
What formalities? For
application is further, my lord, numbered, my lord. Insofar as the scrutiny and the defects, my lord, before the application is numbered, my lord, there are further formalities which
That's
possibly.
why that's why you show that you filed an application on first, but it was taken as a filed on 21st because there are some all scrutiny were done in between. Where is that?
My lord, that I had indicated from the application itself, my lord, which was affirmed, my lord, on 21st of November. From my application, your lordships will see it was affirmed on 21st of my lord, November.
Next.
My lord, and my lord, the other, my lord, Stroud's, my lord, filing, delivery of a document to a court office is sufficient to constitute filing within the terms of Rule 2.3.1 of the Civil Procedure Rules. My lord, it's the English rules which is there. But just to, my lord, indicate and, my lord, canvass my contention that, my lord, the fact that I had brought the application on record along with the affidavit, my lord, and considering, my lord, in the facts of the circumstances, this is not a case, my lord, where after a long period of delay, this application was filed.
Okay.
There are formalities, my lord, which at least takes through 2-3 days. In our case, the application was filed, my lord, on 29th of November, my lord. Lordships will kindly permit the defendants to, my lord, file the written statement. It's a peculiar facts and circumstances, but your lordships have the right, my lord, to exercise the discretion.
Okay.
Only one thing, as the definition in Stroud's, delivery of a document to a court office, this would constitute the act of putting it in the central filing, not the affirmation. Number one. Number two, same thing, the definition of file in Words and Phrases also. The filing would be on the date when it is tendered to the central filing, my lord. If central filing takes 3 days to number it, that, my lord, my learned friend is entitled to the benefit.
That's I'm telling. Where is
But
the evidence to show
there is
that?
no evidence to show that he put it to the central. He could not have put it to the central filing on the 21st because the summons were taken out on the 26th. Obliged. But with your lordship.
Fixed matter. Fixed matter. The defendant has filed the present application being GA.
GA2.
GA2 of 2025 and 2024, praying for extension of time to file return statement, hearing concluded, CAB.
Obliged.
Yes, next.
Number 11 was
Great.
my lord special ticket.
Password. Call the fixed matter.
Your lordship was
For the award.
the setting said, my lord.
Yes.
Well, your lordship will remember that, my lord, I had shown you, lordship, the share purchase agreement, where, my lord, the price per share is ascertained, and, my lord, that is the consideration for transfer. And, my lord, also, your lordship will remember that, my lord, this provides for transfer in two tranches, tranche 1 and tranche 2. My lord, there is no condition precedent, my lord, for the transfer of tranche 1 shares. My lord, there is a condition precedent for tranche 2 shares, but the condition precedent is not payment of incentive. So, my lord, and, my lord, the terminology used in the agreement is clearly that, my lord, there is a determination of price per share, and it is at that share, that price, the share will be transacted. That part is done and completed. Price paid, shares transferred. There is no dispute about that. And, my lord, then, my lord, I had raised before lordship the question, then, my lord, what was the consideration for the latter part of, my lord, the transaction, my lord, which was admittedly identified by my learned friends as, my lord, tax incentives. Now, my lord, so far as tax incentives are concerned, I had also shown to your lordship that this is an incentive that would be payable to, my lord, Haldia Petrochemical Limited, which was not a party to the arbitration agreement. That was kept outside the purview of the agreement. Now, my lord, the question is, my lord, who can then claim performance of this contract? My lord, if at all it is a contract, well, it is Haldia Petrochemical.
If the Haldia is not here, and the agreement is between whom?
Well, the agreement, well, here your lordship will see, the agreement is also, HBL is a party to the agreement, but not a party to the arbitration agreement.
Oh, that's what I'm telling you.
Well, that is the essential distinction. Well, party to the agreement, but not a party to the arbitration agreement. Well, your lordship will kindly, well, just
have you taken this ground in the
Yes, very clearly.
What is the finding of the arbitrators tribunal?
Well, the tribunal, my lord, ultimately goes on, my lord, a very convoluted my lord,
on this point, why the Haldia is not
on reflective loss as to, my lord, how, my lord, today if this is not paid to the company, it will attempt, my lord, ultimately result in a loss to the company, and how
Which
that
company?
Well, Haldia Petrochemicals. Well, let me clarify it. Well, it's a very long award. I shall have to take your lordship to it. But, my lord, let me just identify the point that your lordship has asked me to on. My lord, what is the argument? The argument is, yes, this incentive is to be paid to Haldia Petrochemicals, which is not a party to the arbitration agreement. If it is not paid to Haldia Petrochemicals will suffer a loss, of which, my lord, there is no evidence left. If it, my lord, suffers a loss, it will reflect on a loss to the shareholders, applying the doctrine of reflective loss. And, my lord, because it will, my lord, ultimately affect the rights of the shareholders can maintain the action.
Because they are affected party.
Yes. Now, my lord, with the greatest of respect, my lord, then, my lord, Haldia should never have been excluded from the purview of, my lord, the arbitration agreement. My lord, the doctrine of reflective loss, my lord, your lordship will find the courts have been very, very, very reluctant to apply this doctrine. And, my lord, today the doctrine of reflective loss must answer to one more question, which your lordships have consistently held. My lord, your lordships know that, my lord, it is now very, very settled that, my lord, even if there is a provision for liquidated damage, you have to establish that you have in fact suffered a damage. Now, my lord, where is the loss that has been suffered for it to reflect on the shareholders? Everything is notional. Everything is hypothetical. I shall show your lordship the award. My lord, the award is, my lord, a very long award, and, my lord, struggles very hard to get out of all the arguments that we've made. Well, that is the, my lord, politest form in which I can put the words. Now, my lord, here, my lord, first thing is, my lord, we had said before your lordship that, my lord, this is called a share purchase agreement. Nothing more. The title is share purchase, the subject is share purchase, and, my lord, share purchase is, my lord, the product, the goods which are being sold for which consideration being received. The consideration is fixed. There's no, my lord, variation here. There is no single mention in the agreement that, my lord, the consideration is 25.10 rupees per share plus this. On the contrary, my lord, your lordship has seen what is mentioned in the agreement is, my lord, there are representations and warranties. This is their case made out in, my lord, the, my lord, statement of claim also, representations and warranties. Now, my lord, what is a warranty? A warranty is, my lord, ultimately certification of quality of a product. It is used, my lord, usually, well, in the case of, my lord, sale of goods. Now, my lord, what is the warranty attaching to the sale of goods? That yes, these shares are transferable. Nothing more than that. What is a representation? A representation is a promise, but a promise does not mature into a contract until it is accompanied by consideration. Well, these are the fundamentals of contract law as we have read and understood over the years. Now, the question therefore is that, what is this, this concept, which is present in the share purchase agreement, but for which no consideration is provided? Can it then mature into a contract? Now, if it had been a part of the contract, my learned friends, first of all, the agreement should have clearly said that this is a part of the consideration for sale of shares, because without this, you would not have accepted the shares or bought the shares.
The tribunal has taken as an issues or decided?
No, issues have also been framed.
Issues are there?
Yes, there are issues. Well, let me just complete this narrative and I shall come. Now, your lordship will remember that the agreement narrates in great details as to what is the past history of transaction between the parties. And your lordship has seen since 2002, the Chatterjee Group was trying its utmost to buy the majority shareholding of this company. They never wavered. When the government did not want to sell, matter was taken into court and then company lobbied and finally to arbitration. Then, in the meantime, there was an attempt to sell, the majority shareholding to Indian Oil Corporation by issue an allotment. They came and opposed that. That price was determined on, the bidding process, 25.10 per share. They did not allow IOC to, complete the purchase. Why? Because they wanted the shares. At what price? At the price that IOC had offered. And IOC had offered to purchase the shares without any condition attached. Now, today, one has to take this aspect into consideration because this is a commercial transaction. The question is, and when today any tribunal is looking at a contract, it is trying to gather the intention of the parties. Now, today, therefore, the intention that the tribunal would be seeking to gather is whether without this tax incentive being a part of the bargain, the Chatterjee Group still would have purchased the shares. Now, the first thing one has to consider in this aspect, and I shall be addressing your lordship on law on this, is that they don't take into account the fact that IOC was prepared to buy the same shares at the same price without any attached condition. Now, if today that is a relevant factor, then ignoring that relevant factor which is clearly on record is in itself a ground for challenge. Ignoring material aspects or facts or documents on record is correct. Yes. Now, the second feature is here your lordship has seen that there is nothing stated before the completing of the first tranche of the sale of shares to say that yes, these are the conditions that must be fulfilled. Now, today it is not stated anywhere in the agreement that without these conditions being fulfilled, we will not purchase it. Now, here I had shown your lordship the agreement. I shall not go back to the agreement. I had shown your lordship the statement of claim and the amended statement of claim, where they don't use the word consideration anyway. But the expressions used are tax incentives.
Tax incentive.
But a tax incentive cannot be a consideration for sale of shares. An incentive is something that ultimately.
Why it cannot be a part?
No, incentive, a tax incentive is something that will not go to the shareholder. Now, here,
okay.
It is going to go to the company. So, it can't be a part of the consideration. And if one looks at the dictionary meaning of the words, representation. Representation is something that ultimately, when we talk about promissory estoppel, we say that you have acted on my representation. That is a promise. But the question is the promise backed by consideration? I may make a representation. Is it backed by consideration to make it a contract? That becomes the issue. Now, today, it may be a pious expression of a pious wish. Your lordships have seen, I've shown your lordship a part of the pleadings where they say that, you are stopped from resigning from this promise by application of the doctrine of promissory estoppel. That is a part of the pleaded case. Where, we talk about promissory estoppel, we talk about the absence of a contract. Because if it's a part of a contract, it is no longer a promise, which is, ultimately governed by the doctrine of promissory estoppel. So, it is, something which is a part of the contract, then you don't have to, ascribe to the doctrine of promissory estoppel. You say, enforce it because it's an obligation under the contract. Now, just to show your lordship, what was the stand, please, quickly, I shall not labor much over this. Please come to the statement of claim. that your lordship will find at my lord paragraph 4. I shall just show you lordship very, very briefly, very quickly.
Statement explain page number.
My lord, this is volume 3, page number 296.
Yes.
My lord, kindly see just a few lines. The instant dispute concerns the disbursement of incentives to HPL. The dispute concerns disbursement of incentives to whom? To HPL. Then, my lord, will kindly skip over. I don't want to, my lord, labor too much over this. Then, my lord, my lord, condition subsequent to first completion is set out at page 308. Clause 11 of the share purchase agreement.
Yes.
Now, my lord, kindly see there is no condition preceding the first completion. So, my lord, the first completion will go through without, my lord, any obligation to perform, my lord, any tax incentive, my lord, duty, etc. Now, my lord, please see conditions subsequent to the first completion. And, my lord, kindly see D. Government of West Bengal / WBIDC shall grant to the company tax incentives as detailed in Schedule 5. Now, my lord, this is a condition that they mention is subsequent to the first completion. And what will they give? Tax incentive. Now, my lord, this tax incentive is, my lord, something that is ultimately not a part of the price that I have already submitted. Then please have a look at, my lord, page 314. Reference is made to Schedule 5 of the share purchase agreement. And it says again, my lord, please see, my lord, Schedule 5 of the SPA contains a specific agreement between the parties that in the event of any change in law, the incentive given to HPL would only be to the extent of the tax that accrues. So, my lord, again, they talk about tax incentive. And then, my lord, please see page 316, paragraph 28. My lord, they talk about tax. Well, I'll not trouble your lordship. Please see, my lord, now paragraph 37. This is most important.
Paragraph
37 at page 319.
Yes.
Now, my lord, it is most important to note that the entitlement of the claimant to the incentives under the WBIS 1999 arises from the provisions of WBIS 1999 itself. Now, my lord, let's pause here for a moment. Arises out of what? Not from, my lord, the contract, but from the provisions of the scheme. Well, I'd like to read this once again. The important to note that the entitlement of the claimant to the incentives under the WBIS 1999 arises from the provisions of the WBIS 1999 itself.
Yes.
Then it says, read with various approvals, promises made in connection thereto. However, SPA contains a categorical representation and warranty. Incentives would continue to be disbursed. Now, my lord, here it does not, my lord, make an obligation. It's a representation and a warranty. So first, my lord, they say that it is, my lord, a duty, my lord, which arises out of
the
law.
provisions.
Yes. And, my lord, then they say there's no contractual or binding obligation. It says it's coupled with representation and warranty. A representation is, my lord, not a binding obligation under the contract. It may be something that impels you to, my lord, enter into the contract. And the warranty is also not, my lord, consideration for the contract.
No. Yeah. However, the SPA contains the categorical representation.
That's right. Now, my lord, when your lordship has seen the SPA and the SPA, my lord, says share consideration specified.
Correct.
Then, my lord, the representation and the warranty is not a part of the consideration. My lord, it may be a pious expression of a pious wish or a, my lord, well-meaning representation. And, my lord, in fact, for the record, my lord, the government continued to, my lord, ultimately allow them this benefit till, my lord, the GST regime came in 2017. Now, my lord, thereafter, my lord, please see one more paragraph. Paragraph 44. The continued non-extension of such benefits arising out of the WBIS 1999. Again, my lord, it is something that arises out of the scheme. Read with the representations and warranties. Again, my lord, it is only representation and warranty in the SPA is in violation of the principles of promissory estoppel. So, my lord, it's not a part of the contract. Well, I shall show you, lordship, authorities which says that, my lord, today, my lord, promissory estoppel is a doctrine which is applied to, my lord, ultimately obligate a party to, my lord, perform the promise when it is not, my lord, a part of the contract. Otherwise, he becomes obligated to perform the contractual obligation.
Okay.
And, my lord, that is how it proceeded. Now, my lord, thereafter, when we, my lord, filed the statement of defense, taking all these points, my lord, they sought to amend the statement of claim. Let please have a look at the amended statement of claim. Well, that you also will find at page 1051. That's volume 8. Volume 8. Well, I'll only take your lordship to the relevant, my lord, portions.
Page?
Page, my lord, 1051 at paragraph 44B. Well, yet again, my lord, at paragraph 44B, your lordship will find what is stated is, on and from 1st July 2017, as per the representations and warranties made by the respondents to the claimant, HPL is entitled to receive further incentive. So, my lord, again, my lord, it is at best a representation and a warranty. Warranty, of course, my lord, does not apply here at all. My lord, the concept of warranty is misused here. And then 44D. Upon the coming into force of the GST regime, HPL has not been given remission on exemption from payment of GST. Hence, HPL has been making payment of GST to the state of government of West Bengal since the inception of the GST regime and till date. In order to get the entitled incentives, the only mode of disbursal of the same is through the refund to HPL, kindly mark it, through refund to HPL of the amount of GST paid by HPL. Now, who can claim it? HPL can claim it. HPL is not claiming. HPL is not, my lord, a party to the arbitration.
So how the claim has come?
But that is what I'm trying to, my lord, understand even myself. We were, my lord, struggling to understand that even now. My lord, lordship will see how they say.
If
My
you
lord,
go by your submission and this.
Two more paragraphs, my lord. Your lordship will find how they have, my lord, ultimately what is their cause of action for the claim. My lord, kindly see. Now, my lord, paragraph 44E. My lord, they talk about the component of GST. I'll not trouble your lordship with that. Now, my lord, please see. Therefore, paragraph 44F. Therefore, the claim of the claimant in the statement of claim is a money award for the amount of SGST accruing to the government of West Bengal, the refund of which HPL is entitled to. Well, this is their entire case. Lord, kindly, my lord.
So they have claiming the amount for the benefit of HPL, and HPL has not given any claim, and HPL is not a party.
That's right.
That is your.
Yes. Now, my lord, the question is, my lord, today, could my learned friend, in the context of this agreement, which has been executed, my lord, this is now an executed contract because the transaction has taken place. Both, my lord, the obligation to pay for the shares and the obligation to transfer the shares is completed. Now, my lord, this is, my lord, the only paragraph on the basis of which they now, my lord, reposition their claim. Now, my lord, this is interesting because, my lord, this amended claim was, my lord, filed because of the objection that was raised in the statement of defense by, my lord, the WBRS and the government. And, my lord, what is their claim? The claim of the claimant in the statement of claim is a money award for the amount of SGST accruing to government of West Bengal. My lord, first question, can the, my lord, claimant, which is a shareholder, claim this money? Because this is, my lord, a payment advice due to the government, to the company.
That's what I'm telling.
Secondly, my lord, today, if it was a claim of the company, should the company not have made it? Was the company precluded from making it? Was there any bar on the company from making it?
The mechanism provided under the relevant tax complete code in itself from the GST. That's the reason it was kept out of the company.
No, don't say that. That goes against you. Don't say that.
Yes.
So, my lord, the first question is, it is an amount at best. Even, my lord, if we go by their own, my lord, statement, amount which is due and payable to Haldia Petrochemical. Number one. Number two, Haldia Petrochemical could have claimed it but did not. My lord, there was an embargo in claiming it in arbitration, but Haldia Petrochemical did not claim it in any other proceeding which was available, my lord, to it to make the claim. It also, my lord, did not claim it in a writ petition because today, if it is a promise or a representation which has not been performed, then they could have gone and filed a writ petition. Interestingly, my lord, when we talk about the doctrine of promissory estoppel, what do we say? My lord, we say that I have acted to my detriment on the basis of a promise made by you, and hence you can't resile from that promise. My lord, what is the detriment to which the company has subjected itself? Or, if I may, my lord, extend this, my lord, thought a little further, what is the detriment which the shareholders have suffered in purchasing these shares? My lord, there is no case made out. My lord, I will not, my lord, of course, my lord, there is no detriment that has been suffered. But, my lord, there is no scope for conjecture because they have not even made out this case.
Yes.
Now, my lord, when we talk about the case of reflective loss, my lord, which your lordship will find, my lord, discussed in great details in the award, my lord, where is the case of reflective loss made out in the pleadings?
Yes.
Well, I shall show your lordship it is barred under Indian law. But even then, my lord, we understand, my lord, the very fundamentals of, my lord, any, my lord, civil, my lord, adversarial litigation, including arbitrations, is, my lord, the pleadings. If you say that I'm entitled to make this claim because I've suffered a reflective loss, then you must plead this case. I've shown your lordship the only pleading now is paragraph 44B. The case is not pleaded. And the arbitrators have gone on to, my lord, answer a case not pleaded. Arbitrators have gone on to, my lord, ultimately, my lord, misconstrue, my lord, expressions which are, my lord, deliberately used, tax, incentive, as, my lord, contractual obligations. Arbitrators have gone on to record that although, my lord, no party has claimed it to be a contractual obligation, we hold it to be so.
Yes.
And, my lord, ultimately the result is, my lord, the public exchequer is burdened with, my lord, thousands of crores of rupees. Now, my lord, here, my lord, we had taken all these points in the statement of defense. I shall just show you, lordship, very briefly what was our case before the tribunal in the statement of defense.
What was the claim before the arbitration proceeding? What was the claim before of the parties before you?
Before me?
Yes, before this arbitration proceeding, they made a claim.
No, my lord, they claimed for the shares, we gave them shares. There was no dispute.
How the arbitration has come?
Well, arbitration claim because they wanted this tax incentive.
So they might have been given a request to you with regard to that intensive. Who has made a claim to you?
Arbitration.
There was no previous correspondence.
No, so there was one letter, but they then initiated arbitration. They're not paid.
Well, there was one letter and then they initiated arbitration. Well, that is.
But what is the request made before you?
That we should pay incentives to
No, well, the request made to me was that we should pay incentive to HPL.
That's why.
Yes, yes.
That is the request made before.
Yes.
So what was the answer to that?
Well, we said under the new regime, we cannot in fact refund this money because the GST law prohibits us. And your lordship will remember Amrit Banaspati was cited. But that is a different chapter. I shall come to that later.
Okay.
So this is where the matter stood. Now, here, their representation is that promissory estoppel, it is a representation of warranty at best. Now, please see the case made out in the statement of defense. Please have a look at page 601, volume 5. And their case is under clause 11D, which I have shown, tax incentive, representation and warranty. Please see, page 601, para 4.5. Instead, Essex has alleged that under clause 11.1D of the SPA, the answering respondents had to pay certain tax incentives to HPL, and since those incentives have not been paid, the tribunal should direct the answering respondent to pay those incentives to HPL. This is how it is positioned. Then, please see paragraphs 5.12 and 5.13 at page 607.
Yes.
The real dispute, type 5.12, the real dispute as per Essex, therefore, is about the alleged failure of the answering respondents to disburse incentives in the form of remission of refund of excess GST allegedly paid by HPL after coming into effect of the GST regime. It is submitted that it is not possible to disburse incentives under WBIS 1999 as was available to eligible industries under the value-added tax regime, to eligible industries without suitable statutory recognition or without making suitable amendments to the West Bengal Goods and Services Tax Act. This Honorable Tribunal, being a private forum with limited jurisdiction to deal with matters covered by the arbitration agreement, cannot direct amendments to the WBGST Act, nor can it direct the executive to formulate a policy framework or issue notifications to implement the WBS 1999 under the GST regime. The relief has claimed, in effect and in essence, however, seeks a direction from this tribunal on these very lines, which cannot be granted in law. As such, the issue being raised by Essex is not justiciable and certainly not arbitrable. Without prejudice to the above, Essex is seeking to enforce an alleged undertaking of the government or a government agency made in a contract. Enforcement of such undertaking can be made by a command of court and not by an award in a quasi-judicial proceeding. Then your lordship will please see 5.30. That's at page 611. The answering respondent further submits that if the interpretation as provided by Essex to Schedule 5 were to be accepted, then the agreement in Schedule 5 and the remission being claimed by Essex for HPL would clearly be in the nature of a refund of tax. Such agreement in any event cannot be enforced, being void under Section 23. So, the point of illegality is also taken. Then, also please see 5.3 to 5.5, 605.
Yes.
Here, the point was clearly taken. Essex has no direct cause of action. Essex does not have any independent or direct cause of action in respect of the dispute as raised in the SOC. Further, it has neither pleaded, and none exists, a case of actual loss or injury caused to on account of non-disbursal of the incentives. There is not a single averment as to how the alleged breach of clause 11.1d, read with Schedule 5, or the alleged breach of any of the representations and warranties have any bearing on or effect on Essex. It is a settled principle that in order to redress wrong done to a company or to recover monies or damages alleged to be due to a company, the action can be brought by the company itself and not its shareholder. A shareholder in its personal capacity cannot bring such an action. In these premises, the initiation of these proceedings by Essex is wholly misconceived. And then, of course, we go on to say that the notion itself is, misconceived because ultimately it was only a question of purchase of shares. Now, if your lordship kindly has a look at, paragraph 6.16, page 619. This is, with regard to, what they can do under the provisions of the, what is the, provision of the GST regime and how it, reflects on the claims. Because, we have already taken the point that you cannot today direct modification of government policy or, modification of statute. Now, here, I don't want to trouble your lordship, there is a lot written about this, but this is the essential pleading. I don't want to unnecessarily take your lordship through paragraphs which are not immediately relevant. Now, so far as this is concerned, your lordship will now, kindly look at the issues that were framed. I shall not take your lordship to the award, but please see the issues that were framed. Then I shall take your lordship to a bit of the evidence and then come back to the issues and award. This your lordship will find at 2168, volume 16.
Yes.
Please have a look at the issues a little carefully. 2168. First issue. Have the respondents acted in breach of their obligations to whom? To the claimant. Under the share purchase agreement dated 11 September 2014, and in particular the obligations contained in 11.1d. Now, so far as these obligations is concerned, my lord, first, my lord, point of determination, is it an obligation under the contract at all? And my lord, the performance of the obligation is, my lord, to the claimant, my lord, which is Essex and not, my lord, the company. Have the respondents acted in breach of the representations and warranties contained in the SPA, and particularly clauses 8.4 and 8.5? Now, my lord, the representation and warranty, my lord, is, my lord, identified as representation and warranty. Now, my lord, the question is whether the breach of the representation and warranty would translate into a breach of contract. My lord, that question was argued, but that was never answered. I shall show you, lordship, the part of the award. Then, are the respondents barred by estoppel from refusing to make payment of the claim made by the claimant? This is again, my lord, a claim made by the claimant. Are all the obligations undertaken by the respondent to the claimant under the SPA discharged by the performance on the part of the respondents as alleged in the statement of defense? Because we said that obligation is discharged because we transferred the shares.
Correct.
Are the reliefs claimed by the claimant barred by reason of any statutory provision as alleged in the statement of defense? Is the claim made by the claimant or any part thereof barred by waiver or acquiescence or any other ground as alleged in the statement of defense? Are any provision of the SPA unenforceable by the claimant against the respondents as alleged in the statement of defense? My lord, I shall just pause here for a moment. My lord, one of the points that, my lord, had been taken is, my lord, if this is a part of the consideration, then, my lord, transfer of shares, my lord, being, my lord, in the nature of securities, is, my lord, governed by the provisions of the Securities Contract Regulation Act. And, my lord, the law, my lord, is very, very clear that, my lord, these transactions must be, my lord, ultimately governed by the, my lord, concept of spot delivery, which is, my lord, completion of the transaction within 24 hours of initiation of the transaction. Now, my lord, here, the transaction happened in two tranches. Part 1 shares paid, Part 2 shares paid. Now, my lord, today, if this is a part of the consideration, it is deferred for performance indefinitely at later dates which are not identified for a period of over 19 years, but it will be clearly hit by the provisions of the Securities Contract Regulation Act and hence illegal and consequently void under Section 23 of the, well, of the Contract Act. Then, well, at paragraph 7, clause point 7, are any provisions of the SPA unenforceable by the claimant against the respondents as alleged in the statement of defense? Because they don't have a cause of action. Is the claimant not entitled to any of the reliefs prayed for by the claimant for any or all of the reasons stated in the statement of defense? Whether the claimant has established that the alleged breach of clause 11.1d read with schedule 5 of the SPA or the alleged breach of any of the representations and warranties has caused any loss to the claimant, or whether the claimant is entitled to any relief. Now, my lord, kindly mark this. My lord, issue frame was whether the claimant has suffered a loss.
Correct.
Then, my lord, 10 is whether the incentives under the WBIS, my lord, 1999 can be extended after 1st July 2017 without suitable statutory recognition and without making suitable amendments to the WBGST Act or the rules and regulations framed thereunder, and or without formulation of a policy, framework or notification to implement the WBIS 1999 under the GST regime.
Yes.
If the answer to issue number 10 is in the negative, can the claimant at all seek a direction from the tribunal as prayed for by the claimant? Whether the entire claim or alleged cause of action based on the discontinuance of incentives available under the WBIS is premature in the absence of statutory recognition of such incentives under the GST regime. Does the claim made by the claimant amount to exemption or remission of tax? Whether any exemption or remission of GST can be allowed, dehors section 11, to what relief is the claimant entitled, so on. Now, my lord, here, now, my lord, very, very important, my lord, if we have to, my lord, ultimately stick to the fundamentals of pleadings and proof. Well, your lordship has seen that they have never pleaded in the statement of claim or the additional statement of claim that this is, my lord, a contractual obligation which, my lord, the claimant, Essex, is entitled to enforce. B. My lord, Essex has never, my lord, come forward and said that it is entitled to enforce this as a part of the contractual obligation, because it says promissory estoppel, it says representation, it says warranty. And, well, it does not say I am entitled to enforce this as a part of, my lord, a contractual obligation, because, my lord, ultimately I have suffered a reflective loss. No pleading. No pleading at all. Now, my lord, the very fundamental rule of our jurisprudence is you cannot prove what you have not pleaded.
Yes.
Number 3, my lord, there is no pleading or evidence of loss actually suffered.
Yes.
Number 4, my lord, you cannot ultimately, my lord, resile from an admission that you have made yourself in the pleading. And I have shown you, lordship, that the admission is that ultimately, my lord, this is a, my lord, representation, which is a promise for which we are entitled to invoke the doctrine of promissory estoppel. Number 5, they have never themselves said that this is not an incentive. This is something that has been given the color of an incentive, the language of an incentive, but is not an incentive. Because, my lord, kindly remember 44B. They said that we are entitled to a money award.
Correct.
Money award, not, my lord, a money award, not, my lord, an incentive. Now, my lord, here, and the next question was, my lord, with regard to, my lord, whether, my lord, there can be, I'm sorry, my lord, saying something.
No, money award and incentive. Incentive in type of the money decree. If you are entitled to get the incentive, that is a money decree. It is not other than the.
Well, your lordship may look at it that way, certainly. But, my lord, kindly see, my lord, how the claim proceeds and how, my lord, now the attempt is to, my lord, infuse this in the, my lord, amended statement of claim in one paragraph. They claim incentive throughout. Now, my lord, the question is, well, an incentive which is given under a scheme, and they say we are entitled to this under the scheme.
Okay.
Whether, my lord, it can suddenly become a part of, my lord, walk out of the scheme and walk into another document which becomes a contract. My lord, either you can claim it under the scheme or you can claim it under a contract. There's cases, pleaded cases, we are entitled to claim this as a part of our scheme, of the scheme. We are entitled to, my lord, the performance of the scheme obligations, not contract obligations.
Okay. Yes.
And, my lord, when we raise the question that, my lord, this therefore, my lord, because, my lord, ultimately it is a share purchase agreement and share price is ascertained and the transaction is completed. Hence, my lord, this does not answer a contract, and this is two separate parts of one whole. And you can't ultimately amalgamate them and make it into one composite whole. My lord, that, my lord, is a case argued, your lordship will find from the affidavit, from the award. And that is, my lord, a case which has, my lord, been, my lord, would I say, my lord, ultimately very cursorily brushed aside. Now, my lord, in this context, your lordship will also remember, my lord, we are now also trying to construe the contract. Now, my lord, in construing the contract, my lord, I shall, my lord, cite the judgments, my lord, on the next day. My lord, your lordship will see that, my lord, the intention of the parties has to be manifested. The intention of the parties is to buy the shares come what may. Incentive or no incentive. I will buy the shares come what may. And, my lord, that is, my lord, clearer than ever, because, my lord, IOC was ready to buy these shares at the same price come what may, without, my lord, any incentive, any tax, any concession, etc. Now, my lord, if this is, my lord, a relevant factor, and, my lord, if today your lordship finds from the record that right from 2002, my lord, the Chatterjee Group, my lord, which here is represented through SX, was, my lord, completely bent upon, my lord, trying to, my lord, get these shares, and for that purpose they went on litigating, my lord, to great ends. Well, then the question is, my lord, whether today it can be said that no, without this we would not have taken the shares. Now, my lord, let us also understand, my lord, very fundamental feature of the Contract Act. If today, my lord, the shares can be taken at 25.10 and the chapter closed, then, my lord, that is the consideration. If, my lord, the shares have to be taken against 25.10, but with the obligation of the government to give back, my lord, 2,500, then, my lord, the question is whether that is the contract. Now, my lord, your lordship will have to then rationally construe the contract, my lord, which is a duty that must have fallen on the tribunal. The tribunal has a duty to, my lord, interpret the contract, and, my lord, fundamental rule, my lord, which is the ground for setting aside is, my lord, if, my lord, no rational person could have reached the same conclusion, then it must shock the conscience of the court. Now, my lord, ultimately, what it boils down to is that yes, I will sell you my shares at 25.10 rupees. So you will give me 25.10 per share, but then I will give back to you 2,500 or much more.
Yes.
my lord, question is whether, my lord, this was a reasonable or rational conclusion, because, my lord, ultimately, the essential transaction under the document is the share purchase. Now, my lord, in this context, please have a look at, my lord, some of the questions that were, my lord, or, my lord, the case made out in the affidavit evidence. Now, my lord, we have seen the pleadings.
Evidence led.
Yes, yes. Evidence led, and, my lord, please see what Mr. Punnendu Chatterjee, who led evidence on behalf of the claimant, what is, my lord, his evidence? Very briefly, my lord, I'll not, my lord, trouble your lordship with most of it, but just a few paragraphs. My lord, a part of his affidavit is at page 740, volume 6. I'll just show your lordship 3 paragraphs. Because, my lord, now, after the initial, my lord, statement of claim, the attempt is to amend. 44B, my lord, it says now we claim a money award. And claim a money award on behalf of HPL. And claim it on the basis of reflective loss, which is not pleaded or proved. And now, my lord, please see what is the evidence. My lord, please have a look at paragraph 90 at page 740.
Yes. Claimant's witness.
Yes, my lord, claimant's witness.
Yes.
My lord, ultimately, your lordship will see, my lord, this is what he says. Therefore, while entering into the SPA, I was skeptical of acting on the basis of such promises as noted above. And during the discussions to finalize the terms of the SPA, I insisted that the promises made to me by the concerned ministers and senior bureaucrats be reduced in writing. Respondents voluntarily agreed to incorporate such assurances in some detail. As I can recall, the following terms in the SPA, which are relevant for the purpose of this arbitration, amongst many others, reflected the promises which had been made to me personally by or on behalf of the respondents. Now, my lord, pausing here for a moment, my lord, he says promises made by the respondent again. And he says he was skeptical in entering into this agreement. Now, my lord, the question would be whether he would have entered into this agreement for purchase of these shares if the promises had not been made. Well, that is what I should show you, lordship, from the cross-examination.
No, he stated that amongst other reflected the promise which had been made to me personally by so if we take this evidence on as it is,
yes.
So as per his in the agreement there is no promise.
Yes. Yes. Now, my lord,
so if it is read together, then it will come as a reflected as a promise.
My lord, I do not, my lord, say it is not a promise.
Correct.
I accept that it is a promise.
That's why
I accept that it is a promise. The question is whether the promise, my lord, matures into a contractual obligation.
That's why the promise reflected as a promise, but it is not in the agreement as
That's
a promise.
Right. That's right. That is my case.
That's why,
That is
because
my
if we read reflected the promise which has been made at a personally.
That's
so
right.
it is not the agreement as a promise.
Absolutely, I'm very grateful, my lord. That
But-
is, my lord, what I'm, my lord.
But if it is taken into consideration as a whole, then it can be.
Yes, of course, of course. Of course. But, my lord, the consideration of the whole will ultimately, my lord, skewer the entire transaction. Turn it on its head. Now, my lord, please see, my lord, he sets out some of the clauses, and then please see clause 11.d, how he represents this. My lord, this is, my lord, at the bottom of page 740. Clause 11.1d, by which the respondents jointly and severally covenanted and undertook exclusively to the claimant that the respondents shall grant to HPL tax incentives. Now, my lord, let us read this a little carefully. My lord, respondents jointly and severally covenanted and undertook to the claimant that, my lord, the respondents shall give HPL tax incentives. This is, my lord, a very carefully worded sentence, because now, my lord, it comes after statement of claim, amended statement of claim, statement of defense. They know what our case is. But, my lord, still they don't say. My lord, the represent words used are, my lord, covenanted, undertook. Now, my lord, the question is, can it be a part of the consideration for the contract? And then, my lord, please see the next line, Schedule 5, which contain the details pertaining to disbursal of unavailed incentives to HPL as part of the contractual covenants. Well, it's the first time, my lord, this expression is used, not in the pleadings. For the first time, it finds, my lord, place in evidence. Schedule 5, which contain the details pertaining to disbursal of unavailed incentives to HPL as a part of contractual covenants and undertaking given jointly and severally. Now, my lord, the question is, my lord, today, Can you plead contract for the first time in evidence? First question. The second question is, my lord, if it is a contractual covenant, well, it is a contract entered into with HPL. And my lord, there was no bar or fetter on HPL, my lord, ultimately seeking to enforce this contract. Now, my lord, this is the, my lord, evidence. One more paragraph only I'll show you, lordship, paragraph 105. My lord, please have a look at paragraph page 38. Constant attempt to improve the case. 38, well, I'm sorry, page 745. Internal page 38 of the affidavit.
Yes.
The respondents have acted in breach of the representations and warranties contained in clause 8 of the SPA, which they made exclusively to the claimant. Now, my lord, the attempt is to say that you have made this promise to the claimant, not to HPL. Including a representation and warranty in clause 8.4, that the respondents had requisite capacity, instructions, and authority to enter into the SPA and perform its obligations thereunder, and a further representation and warranty in clause 8.5 that the SPA constituted legal, valid, and binding obligation enforceable against both the respondent at the instance of the claimant. Well, a case made out for the first time in, well, an affidavit. So, well, I'll read it once again. Well, kindly forgive me. Respondents have acted in breach of representations and warranties.
Correct. In terms of clause 8.
Yes. Which they have made exclusively to the claimant. Now, my lord, HPL is not in the picture. This is made to SX. My lord, the obligation to pay incentive is now made to SX, according to my lord, according to the witness. Including a representation and warranty in clause 8.4 that the respondents had requisite capacity, instructions, and authority to enter into the SPA and perform its obligations thereunder, and a further representation and warranty in clause 8.5 constitute. Now, my lord, this is always mentioned as representation, but what does this mean? He said this constituted a legal, valid, and binding obligation enforceable against both respondents. Well, this was not the case pleaded. This is a case argued by my lord witness on behalf of the claimant. And, well, please see, the respondents have also acted in violation of the contractual covenants and undertaking given by them jointly and severally to the claimant exclusively. Because, my lord, ultimately they are trying to keep Haldia Petrochemical out of the picture.
Because they come in.
Yes. Now, my lord, this is a complete convolution of the case made out in the pleadings.
Have you taken in this point in the
Yes, yes, my lord, we have, my lord, argued this threadbare. Your lordship.
Cross-examination, you put the question.
Yes,
this
yes.
Is not in a
Well, I shall show you, lordship. I shall show you, lordship. Contractual covenants given by them jointly, severally, exclusively in clause 11D of the such and such.
And how far this could go into the evidence?
No, my lord. Well, the only thing is, my lord, here, my lord, evidence, my lord, ultimately, if it is material to, my lord, gather what the intention of the parties was to the contract, to that extent, your lordships can look into it. Well, otherwise, my lord, section 91 written document, your lordship will look at the written document. Now, my lord, let me even confine myself to that. I'll be very happy to do that. If by applying, my lord, the section 91 principles, the section 92 principles, your lordship looks at the share purchase agreement and nothing else. The question is, does it talk about, my lord, a contract or a binding obligation? No. So, my lord, here, my learned friends are trying to now, my lord, construe it as a binding contractual obligation by, my lord, connecting the dots and saying that in the course of meetings, representations were made to be by ministers and bureaucrats. That, my lord, we will give you the incentives. Okay. My lord, your lordship is absolutely correct. My lord, normally, my lord, your lordship would look at only, my lord, the document. Because the rule of, my lord, evidence requires us to confine ourselves to the written document and not to, my lord, try to construe it by
total evidence.
By looking. But, my lord, when the witness comes forward and said that, my lord, I have been given to understand that this is a contractual obligation they will undertake.
That cannot be over and above the document.
That's right. And, my lord, this is unfortunately something, my lord, that, my lord, your lordship will find has been perhaps a little casually dealt with, my lord. That is the best expression I can use. Now, my lord, please see. Now, my lord, this says the respondents have failed to grant the said incentives, thereby giving rise to reliefs as claimed by the claimants. Now, my lord, please, my lord, pause here for a moment. This is not something that the claimant is entitled to in the first place. But they say, my lord, please see, they say that because it was promise made to the claimant is entitled to enforce the promise. First of all, it could not have been a promise made to the claimant. It is a promise made to the company. And my lord, the shareholders are different from the company. My lord, this, my lord, your lordships have held in number of cases. My lord, the property of the company is not the property of the shareholder. The shareholder is not, my lord, the company per se, so on and so forth. But, my lord, the representation made, please see how dishonest this representation is. They say because this promise was made to Essex, Essex alone is entitled to enforce the promise and receive this compensation on behalf of the company. Now, my lord, where is this case pleaded? And, my lord, if the tribunal has gone on the basis of this case, where is it found? Find, my lord, the foundational pleading for this case.
Yes.
And, my lord, on this basis, they claim how much? My lord, 600.
4 crore. 604 crores.
604 crores on that date. Well,
kept depositing and then
yes. Now, my lord, this is all that I want to show your lordship from the evidence. Now, my lord, let me just show your lordship, since your lordship asked about, my lord, the cross-examination, just a few questions in cross-examination of, my lord, the same witness. My lord, his cross-examination, your lordship will find, starts at page 1091, volume 8.
Yes.
My lord, please see, my lord, 1091, question 56 onwards. Will I be right in saying that in the year 2002, TCG only wanted to acquire 51% shares in HVL? Now, my lord, this goes to the background of the matter. My lord, he says, because, my lord, why this is relevant, let me tell you. Even in 2002, you wanted, my lord, majority control.
Achha, 51.
Yes. Will I be right in saying that in the year 2002, TCG only wanted to acquire 51% control in shares? Kindly see the answer. I cannot answer straight away because 20 years have passed. Now, my lord, let us again pause for a moment. If, my lord, you had wanted to acquire 51% shares in 2002 and you've maintained that stance, you've gone to court, you've gone to the company law board, you've gone to arbitration, then, my lord, are you now going to say that, no, I didn't want that? And so, my lord, the evasive answer comes in here. Now, my lord, next question, please see. He's shown the agreement of 2002, my lord, which says that 51% shares.
Yes.
Question 57. Will you now be able to answer the question? It is an 11-page document which is poorly legible, but I will do my best to respond to the question. If the question stems from the document shown to me, it will be worthwhile if a particular section of this particular section is pointed out because there are multiple sections where parties' intention to transfer shares have been discussed. But he does not say that he did not want to acquire 51%. May I then draw your attention to clause 5 of the agreement, which spreads over pages 4 and 5 of the document. Clause 5 of this document talks about the government of West Bengal shall cause WBIDC to transfer such of his existing shares in HPL so as to ensure that CPMC, which is my Lord Chatterjee Group, has 51% of the total paid up capital of HPL. It goes on to end of the clause which says that in the event GOWB and WBIDC at any point of time intend to transfer or any part of their remaining shares, Government of West Bengal or WBIDC shall first offer to CPMC, who shall have the right of first refusal. If CPMC also wants to acquire at any time all or any of these shares of WBIDC of the Government of West Bengal, these shares shall be sold by the WBIDC or Government of West Bengal to CPMC at a price that may be agreed between the parties, and failing that, at a price to be determined by independent valuation done by a valuation expert of repute, who shall be jointly determined by WBIDC or the Government of West Bengal and CPMC. With this, the answer to the question posed is self-evident that we wanted to acquire not just 51%, but the entire shareholding of WBIDC. Because, my lord, not only was the agreement to acquire 51% in 2002, but right of first refusal. And, my lord, shares to be determined on the basis of valuation. Valuation exercise carried out when, my lord, IOC was sought to be brought in, and, my lord, 25.10 per share was determined on the basis of such valuation exercise. Will I be correct in saying that the remaining shares referred to in paragraph 5 of the agreement included the shares which are the subject matter of this share purchase agreement of 11 September 2004? 2014? I would think so. So, my lord, he wanted to acquire these shares notwithstanding anything else. Will I be correct in saying that 51% shares agreed to be acquired under the agreement of 12th January 2002 were to be acquired at par value? Yes. The unread portion of clause 5 has enumerated both the price and the terms of payment for the transfer of those shares. What was the reason for which you agreed to a determination of the price for the remaining shares through a valuation mode under the agreement dated 12 January 2002? This 11-page document is a reflection of reasons of both the parties and a culmination of a negotiation process. Do you find from this agreement of 12 January 2002 that under the same, the TCG agreed to bring in and arrange all funds, etc.? Well, this I don't want to trouble your lordship. This is with regard to their failure to infuse funds into the company after the first day. Well, that is, my lord, question 62. My lord, it's a very long, my lord, answer. Then, my lord, there was an objection raised to the question. And, my lord, ultimately the objection was overruled by the tribunal that your lordship will find, my lord, at page 1097 before the answer. Mr. Sarkar had objected to my asking this question to the witness.
Yes.
And that objection was overruled, and then after the 155 million shares got transferred and consideration paid, CPMC undertook fresh cash infusion, etc., 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 which is not really relevant for the present purpose. Well, then, my lord, it is with regard to failure of their obligations, my lord, to perform, my lord, the conditions of the 2002 agreement, which, my lord, I will not trouble you lordship with. Then please have a look at question, my lord, 64, 65, 64, I'm sorry. Could you tell the tribunal as to whether any efforts were made to obtain the valuation of the remaining shares, which TCG was also interested in acquiring right from 2002? Now, my lord, these are the shares which are the subject matter of the share purchase agreement. There was no valuation done as per clause 5 of the 12th January 2002 agreement, to my knowledge. Efforts were made to have a valuation done. Valuers' names were presented to the government of West Bengal, WBATC, in March 2005. No selection by the WBATC or the government of West Bengal came forth, and thereby nothing was done. Will I be correct in saying that in this regard, there was a separate one-page agreement entered into between TCG and the government of West Bengal on 14 January 2005? You may refer in this regard to paragraph such and such. Yes. Will I be correct in saying that it was always the intention of the parties that the remaining shares, which are now the subject matter of the SP of 11 September 2014, were agreed to be acquired at a value determined or price discovered? It was an intention of the parties that as per agreement referred at the time the agreement was signed, the intention was valid. Now, my lord, please see. My lord, now, my lord, how he tries to, my lord, get out. Because, my lord, today the question is that if you were prepared to acquire it at the value determined, then how are you adding, my lord, this, that, and the other to it? My lord, when we ask this question, will I then be correct in saying that this was always the intention of the parties that the remaining shares, which are now the subject matter of the SP of 11 September 2014, were agreed to be acquired at a value determined or price discovered? The answer is, it was an intention of the parties as per the agreement referred at the time the agreement was signed. The intention is valid. However, subsequent events will show that there was no follow-through to conclude the transfer of the remaining shares. So it was not the intention of the parties always. It was the intention of the parties maybe at the time of signing of the agreement. And as in various forums, it was disclosed that the 14 January 2005 agreement signed by the government officials were not to be followed through. And this was in the various court documents. Witness shown the agreement of 14 January. Well, the agreement of 14 January is there. And then, well, 67. Will I be correct in saying that in the proceedings filed by the TCG group before the company law board, it had alleged failure on the part of the government West Bengal to honor the agreement of 14 January and had accordingly prayed that the balance shares of HVL should also be transferred to TCG on such valuation as the CLB may deem fit and proper? The prayer be of the relief is that appropriate orders be passed, direct the entire shareholding of the respondent number 2 in the company to be transferred in favor of the petitioner at an agreed price of 14 per share. Will I be correct in saying that the price of 14 per share in prayer B is confined only to 60% of the holding of WBIDC? And the prayer B goes on to say, and on such valuation in respect of the balance shares held by the respondent to, as this honorable board may think, it is correct. Will I be correct in saying that apart from the proceedings before the CLB, TCG had also filed suits seeking to enforce the agreement of 14 January 2005? You can have a look at the agreement. My lord, the answer is paragraphs 8.3 at page 59 of the statement of claim confirms the question posed. Was it ever the representation of TCG that without the incentives being given, the group would not proceed to purchase the balance 520 million shares? The question is incomplete in my view. The total package of the consideration of the price of the shares, the payment terms on the shares, and the incentives to be given together with the restructuring of the company, and this has all been enumerated as to what is the total package. Illustratively, if the price of the share was 1 rupee, the rest of the package could have changed. Without incentives, we would not have bought the shares of the company from the government of West Bengal. Now, my lord, this is the most critical part of the whole thing. Now, my lord, does your lordship find that expressed anywhere apart from, my lord, the evidence given by this witness? When, my lord, he has been, my lord, fighting tooth and nail since 2002 to get the shareholding. When he prevents IOC from acquiring the shares without any condition attached. And when he, my lord, further finally says that, yes, I've shown you, lordship, the specific parts of the agreement. This is the price determined for the shares.
Yes. Package could have been changed without incentive. The shares of the company on the current. Yes.
My lord, he is conscious of what, my lord, we are getting at. Now, my lord, he tries to, my lord, turn the agreement around, insert, my lord, thoughts into the agreement, insert hypothesis in the agreement, my lord, inject conjectures into the agreement to, my lord, make it a complete different animal than what, my lord, it is on paper. Now, my lord, as your lordship had posed me the question, look at the document. Is this, my lord, clear from the document? No.
Okay.
My lord, your lordship has another matter fixed at 12:30.
That's the difficulty, I know, my lord. But since we've lost out on yesterday, quite naturally, my lord, nothing could be done. My lord, is the possibility, my lord, one more day, my lord, before the
let us come back because I'll not finish in one day. So, again, the vacation.
How much time
some
will take?
progress, my lord, would have been further progress would have been. made, my lord.
I'll
That's
take,
all, my lord.
I'll take at least, my lord, another, my lord, 3 1-hour sessions because, my lord, I'll tell you, lordship, after
3 hours.
My lord, the award is a very large award. Then, my lord,
It
I have
is.
to show you,
That's
lordship,
also
my
a
lord.
case, my lord. That's a well considered award. Of course, my lord, my learned friend would, my lord. Of course, my lord, my learned friend would, my lord, challenge it, my lord. And
of course, it is well considered.
We had, my lord,
whether it is rationally well considered or not.
Well, I would not like to say so, my lord, considering, my lord, who, my lord, the arbitrators were, my lord, I would not.
That is something that
say,
your
my
lordship
lord.
will not, my lord, bear in mind at all as to what is the
No,
purpose.
that also makes a difference. My lord.
My lord, I have heard, my lord, a learned arbitrator, my lord, Justice Rumapal said, my lord, while refusing arbitrations after her retirement, that I would not like my award to be challenged and, my lord, be interfered with by a district judge. But, my lord, there are other arbitrators who have accepted the appointments and who have done so consciously, knowing that they are susceptible to challenge even before a district judge.
Absolutely, no, correct. That, my lord,
So, my
we
lord,
can't.
the name,
If you have
my lord,
chosen yourself, if you offered yourself to be arbitrators, you will be, my lord.
No, so, my lord, when Mr.
Yes.
So when
absolutely.
Mr. Banerjee says considering whom the arbitrators
So
are,
I
my lord,
would like
that
to
is
say,
not
my
a
lord,
fair
they were not rational. I would not, my lord, personally like to say that. But yes, of course, my lord, if they go wrong, my lord, we have, my lord, to correct.
The names of the arbitrators are to be redacted for the purpose of
It's
consideration of a law.
It's happened everywhere in the tribunals.
Yes, yes.
NCLT and other
Correct.
central administrative tribunal. That happens. The counsel for the petitioner has argued the matter at length, but due to paucity of time, hearing could not be completed. A date though?
I want to celebrate Puja now in Delhi. I'm not
12:12 को पूजे को.
You think about your next book.
After vacation only. Before vacation. 2-3 कब है? कितना बजे देता? 12:30.
अभी रख दे रहा है.
I don't want to meet Subho before
24, 25th and 26th November.
Very good.
24, 25, 26 November.
Oh, 25,
Right.
At
I'm great.
12:30.
Yes, ma'am.
Right.
Very
So
good.
great.
Very good. ठीक है. I'll be there.
Thank you.
Great.
Number 5 and 6.
My lord, I appear for the bank.
Your Lordship, I appear for the plaintiff.
My lord, my witness is here, my lord, for cross-examination. Yesterday, Lordship had permitted me to, my lord,
Yes,
come with that
document is
affidavit.
not produced.
My lord, yes.
Not produced.
No, my lord.
No.
My lord, I have prepared the affidavit. In fact, I have served the advance copy also, but we faced an issue today, my lord. My lord, before the oath commissioner, my lord, this person who is the principal officer of the bank, being, my lord, the branch manager, present branch manager, my lord, they are asking for further authority letters from, my lord, the head office, and they have not accepted the affirmation. So, my lord, I have served, my lord, when we went to the, my lord, commissioner for the purpose of affirmation, it was not.
How the commissioner is concerned with that?
I really don't know, my lord. I got a call from my advocate, my lord, saying that this has happened, though we have served the advance copy yesterday evening itself. But, my lord, I thought I would come prepared with the final version. But since it's not affirmed, both the officers, one who is the witness and one, my lord, who is supposed to sign this, the present, my lord, manager of the Circus Avenue branch, both are present, my lord. But, my lord, because of this imbroglio, my lord, the situation, my lord, the affidavit, though ready, is not affirmed.
They left?
No, I think they are here, my lord. No, he's here. The officer is here.
Let it be affirmed.
If Lordship, if I get an endorsement that leave is given,
Leave is granted.
then I can have it affirmed right now, my lord.
Leave granted to affirm the affidavit by the officer who has affirmed this.
And I have come with a competency also here. To leave the deal, affirm ho jaye.
Leave is granted to affirm this affidavit by the same officer who has signed this.
Very good.
Yes.
But let them start crossing.
Your Lordship, we don't wish to file a reply to their affidavit. We would like to make submissions, however, in response to the
Okay, you
affidavit.
cross-examine.
Your Lordship, you
Have
can
you gone through the affidavit? What is their contention?
Yes, I've gone
What's
through it.
the
I can
contention?
Your Lordship, their main contention is that this notice to produce is not maintainable.
Okay.
Your Lordship, this is because it has been done under the unamended provisions of the CPC.
Correct.
However, the amendment that has come in through the Commercial Courts Act, Your Lordship, the form that is to be used is the same form. So, in essence, the notice to produce is in correct format.
Next.
And then, Your Lordship, they have merely said that it's not that they have refused to produce the documents, it's that they require time to take it out because it has been over 10 years. For that, Your Lordship, you have to bring attention to the fact that this notice to produce was issued on the 15th of July. After that, on the 23rd of July, they had in fact stated
I
that
will
they
record an order. You continue with the crossing.
Great. And Your Lordship, just to also mention that in fact these documents came to light during cross-examination on the 2nd of February. Just to bring.
Okay. You for the first you cross-examine. Then
Well, just a quick reply on this, my lord, since Lordship will dispose of the application. My lord, I understand, my lord, even if I don't produce, my lord, what ultimately when the my lord suit would be argued, there may be, my lord, certain inferences that can be drawn considering the overall evidence. But this is the position I wanted the officer to, my lord, take take a stand by in the form of an affidavit. We have indicated just in case we get it in future, we may write a letter. But as of now, it's not, my lord, traceable.
Correct. That's why let the
And my lord, only one question was not, my lord, record, my lord, in the application. They have referred to 3 or 4 questions in course of cross-examination put to this witness. One question, my lord, put to this witness was not referred to. Can you disclose the entire charge sheet and what whether you were management witness in such proceeding? The witness himself said, I have to check since it is 10 years back. So this is the position, my lord.
Leave is granted to affirm this affidavit by the same officer who signed it.
What is your name, sir?
My lord, just appropriate this, I must remind your lordship that the first time I asked him, confronted with one of there were 6 officers, all of them suspended. One officer, I could manage to get a document, the inquiry, where he was management witness. So all I asked, can you check whether you were management witness for the others? Because the effect of that, it's not immaterial. What his stand today is, I will try to show, is completely contrary to what was, that is the reason why I wanted those inquiry proceedings. It's not that I'm just asking for some documents, which is, Maynard, I will put it.
I have never said that also.
So I will be Because of this, the tenure of my cross-examination would not be very soft. My lord, my lord, he has to face it because he is the witness. They have brought him as the witness. Just get those questions, sir.
The defense lawyer never be a soft to the prosecution witness. The defense lawyer never be a soft to the prosecution witness.
But
Unless
I'm
they
not,
become hostile. Unless they become
I am not the defendant. I am the plaintiff.
But not the cross-examination.
Yes. Oh, my lord. There were two styles. There were two styles. My lord, one style is Mr. Anindo Mitra tells us he is the best cross-examiner. He has come is one Mr. Bulu Ghosh. Your lordship, he was a very smooth cross-examiner. The aggressive style was I have seen was Mr. S.K. Kapoor in very aggressive, very aggressive. So I believe there were also aggressive style witnesses. Some, but I have seen what I can do. What I have seen, like lordship has ever seen Sir Ram Jetmalani cross-examining. The best I have seen. The best I have seen. Just wonderful. In art, complete art.
That's why call the cross-examination is art.
From what I've heard, Mr. Shankar Das Banerjee was a brilliant cross-examiner. I have not seen.
Because
So
if you bring the cross-examination or examination in
the entire case should be proved.
But you can't say what the answer of the witness will
Right.
come.
So be
But
very
again,
careful.
you have to put.
Yes.
If it is against you, how you have to cover that?
My lord,
So that's why it is the art.
Yeah. So let's I mean, and we don't get the opportunity these days here at all. I mean, big matters don't come. Yes. So let's start. Where should I start? Yes. Are you aware that Mr. Vishwakarma, the zonal head, had filed a prior suit on behalf of what's his name, UCO Bank in or about March or April 2013. Sorry, not Vishwakarma. Mr. Samantre, Baldev Samantre had filed this, whatever I've said. And see the date of the written statement.
Yes.
Kindly, if a document could be produced, I can comment.
The document is produced, then you can say.
Are you aware that
if the document is produced, then only can say.
So
only I can say.
Are you giving evidence in both the suits or given evidence in only as on behalf of defendant in this suit filed by the what is this WB
WBIDC
IDFC on behalf of IDFC.
I am witness to the case. Defendant.
No, see, there are two cases. One is filed by the bank, another is WBIDC. Correct. In one case, bank is plaintiff, another is the WBIDC, and your bank is the defendant. So you are giving the evidence in both the cases. That is the question raised by Mr. Advocate.
That I have to check, sir.
Huh?
I have to check, sir. That I have to check.
You do not even know. Do you know who has affirmed the written statement in the suit filed by WBIFDC?
I have to consult with advocate. Then I can say.
Who has asked you to give evidence? Who has asked you to give evidence on behalf of UCO Bank?
The communication got through our advocate. That is why with permission communication is through our advocate, Mr. Sanderson and Morgan. Thereafter, on getting permission from my competent authority, I am attending.
And who is your competent authority?
My competent authority is my zonal head, currently zonal head Cuttack.
Currently, zonal head Cuttack.
Therefore, the zonal head Cuttack authorized you to give evidence on behalf of UCO Bank, correct?
Zonal head Cuttack allowed me to attend to honor the communication received from Sanderson and Morgan.
Received from
Sanderson and Morgan, a communication originally of the court.
When you were deputed as chief manager or branch manager after the fraud incident of fraud, were you authorized by the zonal head, Garihat Road branch of UCO Bank?
May I know, my lord, authorization for what?
Authorization to act as branch manager, say in place of the existing branch manager or chief manager of the existing staff of Circus Avenue.
Yes, my lord.
And during your tenure, you are not aware whether any suit was filed immediately after your joining.
My lord, many things are handled by, since it is a high value incidents, many things are handled by controlling office, that is zonal office, and they are not duty bound to communicate everything to the branch.
Everything to the branch.
Which zonal office are you now talking about regarding filing of prior suit or written statement?
My lord, it is zonal office Kolkata.
So I take it that it is the zonal office Kolkata or Eastern Zone which will dictate as to who will give evidence on behalf of the UCO Bank, both in the prior suit and the suit filed by WBA-IFTC.
WBIDFC.
My lord, I am unable to answer this question.
So now, are you at least aware that these prior suit plaint in the prior suit was shown to you on earlier occasions during your cross-examination?
I cannot recall, my lord. Only one suit I have seen West UCO Bank versus West WBIDFC. Number I have forgotten. For that, I am appearing here.
Forgotten. For that, I am appearing here.
Did I ask you about a number? Are you aware now that the plaint in the prior suit was shown to you.
My lord, the point of confusion is two suits are being suits are being uttered. As per my knowledge, I am the witness for the suit UCO Bank versus WBIDFC. But as per my knowledge, I am the witness for UCO Bank versus WBIDFC.
So at least you are aware of the defense which has been filed in this suit filed by WBIFDC, which we call as a written statement.
I could not follow.
No, what
What is
What
the
is the
question?
question? What is
That
specific
at
question?
least you are aware that a written statement has been and he's giving for the defendant. So I mean,
So you are aware of the written statement filed by the WBIFDC in the case filed by the UCO Bank?
no. Written statement filed by UCO Bank in the suit filed by WBIFDC.
Yes.
You are aware of that?
Yes, ma'am.
Yes. Now, was it affirmed by any branch manager of on behalf of UCO Bank?
My lord, I have to go through the documents because these many things are dealt from zonal office, or that is our controlling office, and every information are not passed to the branches.
Or not passed to the branch office.
Which zonal office again you are talking about? Kotok or Goriat Road?
My lord, pertaining to this case, the only zonal office is UCO Bank, zonal office, Kolkata.
Shown the defense, written statement filed on behalf of কি নাম?
686.
in
Statement 686.
কত আমাকে এই CS number কত?
686.
One second. In CS 169 filed by WBIFDC.
169. No, it is
169
renumbered.
ও CS কম হয়ে গেছে? ও being CS com 686 of 2024. Written statement একটু দে আমাকে কপিগুলো ওই প্যাকে Please see page 43. Now, can you say who Bikash Vishwakarma was of the of UCO Bank at the time of verification and affirmation of this written statement?
My lord, Vikas Vishwakarma was the branch manager of Circus Avenue branch. Who succeeded me?
Who
succeeded me? Who joined branch after my transfer?
Who joined the branch after my transfer?
So when were you transferred? In the year, approximate year or month from Circus Avenue?
My lord, May 2016.
Full stop. So I take it Mr. Vishwakarma, whose name appears in this written statement, which apparently was verified in July 2019, was there for 3 years after your transfer with Circus Avenue branch.
My lord, about the tenure, I cannot right now I cannot say, but he was there for long time. Long time means I am saying near about 3 years.
About 3 years. Now, is Mr. Vishwakarma still in service?
Yes, my lord.
Sorry, service of UCO Bank. Huh?
Yes, my lord.
Working in the UCO Bank.
Now, was Mr. Vishwakarma the management witness of UCO Bank along with you in respect of the disciplinary proceedings initiated against Mr. Alois Lakra?
My lord, nowhere Mr. Vishwakarma has signed anything along with me. That is why Vishwakarma joined after my transfer. Mr. Vishwakarma.
No, the simple question is whether he was the witness in the departmental proceeding.
So far I can remember nowhere it is happened.
Where it is?
So far I can remember nowhere it has happened.
Yes.
Do you remember that in answer to question 302, as early as in February 2025, you had said that disciplinary proceedings were also initiated against other employees. 302 to? Yes.
302.
কোথায় গিয়ে বলেছি?
My lord, question was in particular to Mr. Gautam Ghosh, and my answer was yes. Today also I am stick to my answer. In particular, Gautam Ghosh.
কোথায় আছে? কোথায় আছে? Please see your answer to question 304 as early as February 2025, when similar question was asked with regard to other employees. And you had deposed that the controlling office can produce. Do you remember?
Yes, my lord. This question was also in particular to Gautam Ghosh, and I remember controlling office has the must have the data.
Did you make an effort to thank you. Yeah. Which day is this? Oh, no, that is already there. I don't want to. Did you make an effort to get these documents from your controlling office, since you say that the controlling office has authorized you to appear?
My lord, several times I have stated currently I have been transferred to other zone. So I do not have any access to records of our zonal office, Kolkata.
30.
Moreover, in a zonal office also, every employee has not access to everything. storage and use of data is controlled, not open to all. Not open to all employees. Right.
Yes. That. Now, right. Thank you. Yeah. Kindly come to your answer to 303 when you had said, at least for Mr. Gautam Ghosh, disciplinary proceedings, you will check since it is 10 years back. Have you checked on your answer whether you were management witness in charge sheet for at least Gautam Ghosh?
My lord, I have to check and update means I have to go through the document to answer this question.
Go through the document to answer this.
My answer was I have to check since it is 10 years back. That should not be misleaded. My aim of saying was since the incident is 10 years back, whether I was management witness to the inquiry proceedings or not, that I have to check and update whether I have signed or not.
Check and update.
If the document would be produced. That was the submission.
Did you check after your answer as early as in February 2025?
My lord, again, if document will be produced, then I can say that I told. Check means
the specific question was specific answer you are given.
Sir,
Correct?
yes, Lord.
You
Yes,
will
my
check. The specific question is being put to you whether you have checked or not.
No, my lord.
Then
no,
give answer.
It is not possible also because
Whatever it is, first you give the answer to the question which the advocate put to you, then you made an whatever your voluntary statement.
I'll change my course. I mean, this will go on otherwise. Simple thing.
Yes. Next.
Keep. What's answer? What's answer?
No.
Huh? Yeah.
I have not checked.
Just please allow me one more question. Who prevented you from asking the zonal officer, zonal head, to give you access to these documents and verify whether you are management witness in this disciplinary proceeding or not? Particularly when you said you will check and you were personally involved.
My lord, I have done everything in official capacity.
Everything in official capacity.
So personal term should not be used. Check here I have used the word check means if it will be produced because as I have answered earlier, I do not have access to records of Zonal Office Calcutta because of my posting somewhere else.
Through court.
Well,
Through court. After this answer of 303, have you written your head office for allowing you to see the document?
No, my lord.
You have given the answer that the document will produce, and who will produce the document before you?
If it, my lord, my intention was if it will be produced in the court, then I can.
You have stated that Document is with the head office.
Yes,
And
my
you are the witness. You have not written the to the your head office. So who will produce the document before you?
21 CC.
My lord.
Yes, while giving the answer, be conscious. So who will produce before you the document?
Yes, thank you.
My lord, the meaning of my answer was, maybe I have not explained properly. Meaning of my answer was, if the document would be produced, then I can say whether then I can say, because more than 10 years the matter was, and I am unable to recall.
Who will produce as per your understanding?
As per my understanding, if it has been submitted, if it is already in the possession of the court, then it could be produced.
Yes.
Next.
Let us now go to the two transactions in question, being question. Let us take the first transaction of 59 crores. Uh, 59 crores. You have said in your deposition that this money apparently was credited, no, was remitted at the end of the day. At the end of the day. And therefore, end of the day. Do you remember that?
My lord, question was pertaining to transactions during day end process, not end of the day.
Day end process.
Day end process, which do generally take place every day in our Finacle software, that is core banking system software. Core banking system software. So again, I will request no confusion should be there pertaining to end of the day, that is a process only driven in software commands, driven through software commands.
Shown answer to question 49 in examination in chief. Dated 10th September 2024. Which transaction were you referring to in your answer? The first transaction of 59 crores or 61 crores, or the second transaction of 61 crores?
My lord, this is 59.
59.
Regarding 59 transaction.
So, what do you mean by the phrase inverted comma, the end of day in your answer?
My lord, end of day is a operational process. Operational process in our core banking system software, in which reconciliation of transactions at office level do take place in database, and it is a daily exercise before closure of branch.
And when is the closure of the branch? At what time, according to you?
My lord, scheduled time is 5 p.m. closure of the branch, but due to workload at 5 p.m. every day it is not possible. It could be lingered to 6 p.m., 7 p.m. also. Exact answer of this question I am unable to say.
So, in your answer to question 49, in whose name was the amount of 59 crores credited? In your কি বললাম? কোথায় credited? Where does it say bill realized? Credited during end of day on 30th August 2012.
My lord, it was amount was parked into one office account. In our language, in internal language, those category accounts are told are mentioned as suspense account. In this is a internal banking term. Nobody should get confused. In that account,
Get confused in that account.
The amount was parked so that the day-end process could be run for closing the branch of that day.
Closing the branch for that day.
So it was parked in an account of UCO Bank with name of UCO Bank and without name of any beneficiary. Correct or incorrect?
What I can recall, my lord, that is a office account named bills realized account. Bills realized account.
So bills realized account and suspense account, according to you, are the same.
My lord, in earlier question, I have mentioned these type of accounts are told suspense account in banking terms. In banking terms.
Yes. You mentioned about office. Which office?
My lord, office account means these are the accounts allotted to branches. Such type of accounts could not be allotted to customers.
Sorry, can you just
Read the answer.
Accounts allotted to branches. First type of accounts could not be allotted to customers.
Right. Shown para কত এটা না para কতটা 21 para 21 BB internal page 22 of written statement filed by UCO Bank. There is mention that of first the money going to NEFT sell account without disclosing name and then transfer to NEFT cell Circus Avenue, disclosing only transaction reference without reference of any account name. Account name. Which transaction reference is being mentioned here?
My lord, question should be repeated. I cannot understand what is
Repeat the
being told.
question.
Just show him this paragraph. This is what is it.
Commercial quoting.
No, what is the question?
There is reference to a transaction reference. The money is going from first to NEFT head office. Then same day it is going to NEFT.
What is the question? Just a minute. What is the question? Yes.
If you want it.
There is mentioned that first the loan going to NEFT sale account without disclosing name and then transfer to NEFT sale Circus Avenue, disclosing only transaction reference without reference of any account name. Which transaction reference is
Yes.
being mentioned here?
Which transaction reference is being mentioned?
Yes.
Otherwise, শেষ হবে না।
My lord, this is already explained. I think confusion is there. The message type was R42 already.
The message
Type was R42 and it was a bank to bank transaction.
and it was a bank-to-bank transfer.
That bank to bank remittance. That remittance message type itself wrong. That should not be used.
Itself wrong.
That should not be used for remittance for a customer. Since it is bank to bank transaction type, beneficiary name never
Beneficiary name
never get mentioned such type of transactions in such type of transactions.
So
what else is required?
What else is required?
What else is required? I would like to know so that I can answer.
What else is required?
Is it I want to say, is it sufficient?
Yes.
That was the
Absolutely
question.
sufficient. No, what I don't put that. What else is required is not necessary. He's given the answer. Yes. So which bank to which bank are you referring to?
My lord, this remittance was from Bank of India to UCO Bank Circus Avenue branch.
Now, I am showing you a document which has been disclosed on behalf of UCO Bank and forming part of judge's brief. কত number? Yes. Sorry. Part of D42. তাই তো? না. What is it? No, sorry. Yes, sir. Yes. Sorry. D16. Volume 2. 173. 3. My lord, they have not footstop. Footstop. Which has not been exhibited by the defendant. You can see this document. Is this the no, this is the one we are talking. No, is this the one? Where is that credit? লেখাটা আছে। Yeah, yeah. Is this the না আওয়াজ না that এটা কার হ্যাঁ হ্যাঁ আচ্ছা is this the transfer from bank to bank which you are referring to?
My lord, this copy is not legible. Even here it is also not legible. R42 means bank-to-bank transaction in RTGS. This is standard by Reserve Bank of India. R42.
This is standard of Reserve Bank of India.
This copy is not legible. Not at all legible.
Are you aware that these are documents which have been disclosed by the bank
Yes, my lord.
on behalf of the defendant?
Yes, my lord. I am.
My lord, I call upon my learned friend to produce a legible copy of this document because it's their document. I am calling upon him and therefore it will be exhibited.
What is the document? What is the document?
My lord, it's a transfer note from bank to bank, which I am referring to.
My lord, it is screenshot, not transfer note.
What is this?
Ledger screenshot, my lord. This is the screenshot of our monitor, where Finacle system screenshot, my lord. This is just photocopy.
So it will remain in the system.
Yes, any time it could be retrieved. Just a system photo.
Record. True quote. The document appearing in page number 73 is available.
173.
173 is available with the bank. And so, yes, it is. It can be retrieved from the system.
I am now showing you a clearer copy from a laptop. A clearer copy. While making Xerox of this, it will become clearer copy. Do you admit that this document, which I have shown to you, is a screenshot of what has been prepared by a screenshot of the system of the defendant bank?
Yes, my lord, it is a screenshot.
This is the original.
It is the screenshot.
This is a screenshot.
It is shot. Which bank is does the name of this WBIFDC anywhere appear in this document?
My lord, this is also not properly legible, but 103 in the account number, there is scheme, in place of scheme code, character is 103. 103 means it is that suspense / office / sundry account, that is bills realized account. I think that
Please let it
is
go.
bills realized account.
Kindly mention, my lord. Always suspense. I think suspense is misleading. Suspense, right? It is only internal language. Alternate name is office account, sundry account, suspense account. It varies. Office account.
It is only internal language.
Internal language. Alternate name is sundry account, office account.
My lord, may I exhibit that particular document? Because I've shown the clearer copy. So that document
is not exhibited.
No, they did not. Now I will say, then the question will follow. So I am praying.
So, you admit that which you are saying that is not not legible. That is the same copy which you have seen in the laptop.
Give the laptop.
My lord, that was not legible here.
Correct. That is the same copy.
Yes.
Exhibit. What is the exhibit? Last exhibit क्या हुआ?
And let them, with the direction, a clearer copy be later on whenever they want to. Right. Now, and this money, which came in a suspense account or office account or whatever it is of UCO Bank, was standing in the name of UCO Bank, the UCO Bank, for three long days without any name being indicated.
Lord, this is again, I have to repeat. Message type was R42. R42 message, R42. R42 message is bank to bank transaction. So no name gets mentioned in such messages. Hence, that are 59 crore remittance received through R42 message doesn't bear any beneficiary name, since mentioning beneficiary name is out of scope of R42 message.
The beneficiary name was whatever. Have you got it? The answer? Huh? Good stop.
Mentioning beneficiary name, kindly write. Mentioning beneficiary name is out of scope of R42 message.
And how long? Just let me complete this. How long was this lying in account of UCO Bank without any name? 1 day, 2 days, or 3 days?
My lord, what I can recall, it is 3 days. If I will be allowed one voluntary statement, again it will be much easier, I think.
You can say.
Okay. My lord, transaction thing is that one of the bone of contention was genuinity of one of the bone of contention
is genuinity.
One of the bone of contention is genuinity of that 59 crore FDR. In Finacle system, FDR gets generated, FDR receipt gets printed only after funding of account. So before crediting the sum to the FDR account, nobody can generate one FDR receipt. If chronology will be checked, ingenuity of 59 crore FDR could easily be proved.
I give one suggestion to this. I am suggesting to you that after the money was received by UCO Bank and parked in nobody's name with UCO Bank, Mr. Alois Lakra of Circus Avenue branch transferred it to the account 496, ending with 496, so 0496, and nobody else had any hand to this except officers of Circus Avenue branch.
You agree or disagree first?
Again question, my lord, transaction for every transaction.
Please answer yes or no, then you say.
No, kindly, question is not yes or no type, I think.
Okay,
my lord. Again, kindly repeat.
Repeat.
Kindly repeat the
question.
To you that after the money was
Suggestion.
by UCO Bank and nobody's name.
I'm sorry, my lord, I didn't look at the time.
Revenue branch transfer which to the account beginning with 0496 and nobody else had any hand to this except officers of Circus Avenue branch.
My lord, let me answer this question in 2 stages because it is question itself is confusing. Stage number 1. This is not a yes, no
having
type
2 stage answer.
Stage number one is stage number 1 R42 message. Being R42 message, no beneficiary name is available in that message. One sender to receiver message was there, wherein one account number was mentioned stating that this is account of WBIDFC. WBIDFC.
Yes.
As per RBI circular valid during that time, in case of NEFT RTGS message, reliance will be strictly on account number given by the remitter. And I think because of that account account number ending with 496 is mentioned in sender to receiver message of R42, Alois Lacra might have transferred that to the account number ending with 496. Second part of this answer is
Second stage
is none of the transaction in Finagil system or in any computerized environment in banking industry could happen by one user or one employee. So definitely Alois Lacra alone cannot do this.
Who were the other employees? Employees of the bank, along with Alois Lacra of Circus Avenue? Or
who are the other employees, whether they are the employee of the Circus Avenue branch?
For this transaction, what I can recall, no, other employee must be Mr. Gautam Ghosh.
That's all.
No.
Today's.
I'm sorry, I didn't watch. He told me that what are you doing? I didn't know. I just get carried.
We have seen Lordship continuing till 140 also. So unless we stop, it's
Recorded. Defendant's witness is present. Defendant witness, na? Or plaintiff witness?
No, this is defendant's witness.
Defendant witness is present. Cross-examine resumed today, but due to paucity of time, cross-examination could not be completed. During the cross-examination, one document is marked as exhibit.
NN.
Mango.
NN হয়েছে
বলছে ম্যাঙ্গো
ম্যাঙ্গো নেই এখন ম্যাঙ্গো হতে পারে না NN হয়েছে
হ্যাঁ সরি
জিজ্ঞেস করো NN হয়েছে
নাগপুর অরেঞ্জ
NN তো নাগপুর তো
নাগপুর
not
রেকর্ডে আছে ওদের পুরো
not mango
no
not mango then it will go to orange
that is why
that's what I was telling Mr. Bose not mango
क्या बोले the defendant who has filed the
defendant's affidavit in opposition to their application for my lord production of documents
affidavit in opposition
along with the competency my lord
connection with GA 9 of 2025 along with affidavit of competence after serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record.
Lordship will pass some order in that.
And he has stated that as in let the evidence be completed. If it is not produced, I will dispose of this.
And my lord, they said they are not going to use.
He will continue.
I will not use any.
That's why you will continue the examination. He has stated that if it will produce, if it will trace out, he will produce. So I am not disposing of until the cross examination. If he will produce, it is okay. Otherwise, I will.
No, kalke hobe na.
Yes, very well. Then lordship keeps it pending.
I am keeping this pending. Otherwise, I will dispose of tomorrow. He will come again.
No. Then it may be difficult. difficult.
My lord,
Then it may be
then তুই বল আমি বলবো।
Yes, no problem.
My lord, because we will be putting questions to the witness on the documents for which we've asked for production. So the witness will not be discharged until those documents.
That's what I'm telling. So that's why I am keeping this till the total cross examination of this witness.
My lord, no, my lord, there was another instruction, my lord, to pray if the matter could be part heard, my lord, because 25 hearings have taken place before my
Lordship
lord.
has
My
refused
lord,
all of
six
us, but
witness demeanor.
I have no problem.
No, this is the sixth case today morning, since morning.
My lord has seen the witness demeanor. That is why we were making
Yeah,
this.
Not because of that. It is because I've ended and then application is pending. The application for
পাঠাটের কথা বলছি পাঠাটের কথা বলছি
that is now the rule.
Kal bhi hai na? Let it come tomorrow. We'll see to that.
No, I hear this. I'm going to some change.
চেঞ্জ এখন হচ্ছে না কালকে
না না হবে change
Yes, call the list.
Item number 7.
My lord, I beg to appear on behalf of the defendant number 1.
Yes.
Your Lordship, this is our witness is supposed to come for his cross-examination. Your Lordship, our witness is on the way. Would kindly give us 5 minutes. Oh, Your Lordship, our witness is here. Sorry, Your Lordship.
Typically, the witness is sitting in this chair. I entered the court. I saw in the back seat nobody. The witness is not there. I didn't see this chair. Sorry. I didn't see this chair. আমি বাইরে প্যানিক করছি অনেকক্ষণ ধরে আমি প্যানিক করছি ফোন করছি বাইরে দাঁড়িয়ে দাঁড়িয়ে সরি স্যার
Yes.
ক্রস করছি
No. For this,
Resume.
appeared.
Resume.
What is your name, sir?
Shupati Mahapatra.
Spelling?
PASUPATI
PASUPATI.
MAHAPATRA.
Sir.
PW1, huh? PW1 resume. Deep resume, na? Or cross? Cross resume.
Mr. Mohapat, my lord, may I? Mr. Mohapatra, do you remember that on the last occasion, you were called upon to disclose and provide certain documents?
Yeah.
Don't say yes, say yes.
Yes.
Have you brought either of those documents?
One document we have brought, but other document, our management is not agreeing to hand over the document because this document is related to transaction with our company and our client, which is confidential document, which if we disclose the document, there may be the business relation may affect. So my management is not agreeing to hand over those documents.
Could you tell my lord which document you are ready and willing to disclose and produce today?
That is balance sheet, as you have asked for 2018-19. No. 2018-19. Financial.
FY 2018-19.
They've called upon us by a letter. 4 documents.
My lord, I have the originals.
One question has been put on the last occasion, which I see is the question number.
So they produce a true copy of the balance sheet. Should I ask for the produce the document as you are called upon in this question number 104?
Yes. 10.
Produce the document and insurance of consignment. 18 January 18 and December 18.
Yes. Now the letter. Now so far the identical the letter which comes in. Documents evidencing that all consignments of your clients, those took place between January to December, were insured. Now here witness has answered. Now this is all consignment throughout the year.
No.
Yes, all consignment.
104.
Insurance of consignment that took place in the entire year.
My lord, witness is there in the box.
Could you please the documents evidencing insurance of the consignments took place between January 2018, January 2000?
No, December.
January 18 to December.
Throughout the year. Now, the witness is here. Let him go outside. Then I could bite it. Please. Uchit na bola. He has answered.
I have to check in the office and hopefully we will be able to.
They will reproduce. Now, the same document which he has sought for in the question number 1. Now, this claim is an insurance claim. His insurance company, HDFC Ergo. One of my consignment was coming in C. It caught fire. it got damaged altogether. So this is regard to one consignment. Now he wants details of all my consignments throughout the year, which may be with different my hundreds of clients. So this is confidential.
So you mean to say this case is confined to only one consignment?
Yes, and those documents are here. The second document, I need to pull it.
Let it complete.
Yes, the second document, my lord, relevant document to establish.
Question number?
No, in the letter. Now, this is the only question so far.
Yes.
The question, the relevant document to establish the relationship between the plaintiff company and the clearing agent in respect to the subject consignment of the above referred suit. So, with regard to the clearing agent, now this document, my lord, this is also an agreement with me and my clearing agent. The clearing agent has nothing to do with the insurance company. The clearing agent is at Haldia port or in the Calcutta port, who will clear the goods and I will deliver to my client. We used to purchase goods from China manufacturer, some specialized goods used in iron and steel plant. Our customers are JSW, Tata, Jindal, those having steel plants. So we purchase materials and then we have also plant. We improve them, sell it to Tata. At times, we sell it as it is to Tata. That's our understanding. So my agreement with my clearing agent, as I'll say, this is once again, the clearing agent is the party here. So disclosing this, a third party document, so this is, I'm objecting because this is confidential. The third is, my lord, balance sheet. This is a public document. Fourth is also a public document. Is available in the website, ROC portal. In any event, I have given him a copy, which he has asked for. So, and the question put to the witness, I think...
So you have no problem, 3-4 you are producing.
Yes.
One with regard to only the special consignment, which is subject matter of the matter.
That I have produced.
And with regard to the two, that you cannot, because it's the consignment, it is third party document.
Yes, both 1 and 2 are third party related and my confidential information.
No, one is with regard to the subject matter.
No, that is produced. No, all consignments of your client.
No, all consignment. That's what I'm telling you. Asking cause consignment. You are telling the subject matter. It's okay. Already they are
already there on record. It's my case. I have given that.
Okay, that's all.
Yes.
My lord, may you please to find from the question and the letter also that I have not asked for document with regard to consignments. I have confined myself with regard to the insurance of those consignments because a stance has been taken. All other consignments during that year were CIF basis. Only this subject consignment where accident has taken place is on C and F basis. So what happened to those other consignments which were insured, my lord, that is why, my lord, I have called him to produce the insurance document only.
See, you are concerned with the...
My lord, now to cut short, subject to what your lordship feels. Since the answer that has lastly gone, my lord, I am rest. I will keep for my argument. He has already answered that they are not willing to produce. I am happy with that answer.
And the reasons are gone in. The reasons have gone in.
One document.
No, that is with regard to the one document. That is the
one document number 1, Taleb. The one document is a confusion. Then let it be.
No, he has stated one document.
One document I have brought, but other documents, our management is not agreeing to hand over the document because this document is related to transaction with our company and our client, which is confidential document. If we disclose the document, the business relationship may affect it. So my management is not agreeing to hand over this document.
But this client type is clients, is plural. Is a client? This clients is clients. Yes. But I have handed over the 3 and 4. That I have handed over to Mr. Mukherjee.
Question number 104. It at 23rd July. Mr. Mohapatra, please go through question number 104. that was put to you. You will find that you were called upon to produce documents with regard to insurance. Do you say that the document with regard to insurance of other consignment are also confidential documents?
Definitely.
Is it your evidence that the terms and conditions of the agreement that of the agreements that you have entered into with your other clients in respect of other consignments would reflect in the insurance document?
It will reflect because in the insurance document, price, client name, all these are mentioned.
All are mentioned.
Is there any now, are you debarred by either of those clients under by either of those clients in writing not to disclose those insurance documents even before an appropriate court of law?
Please repeat.
Are you covered by either of those clients in
writing
not to disclose those insurance documents even before appropriate court of law?
That I have to check. Right now, I cannot remember.
Do you remember when the accident? When did the accident take place? The date. Do you remember the date?
Is 14th June, early morning. 14th June 2018, early morning.
How did you get the information?
We received this information on 15th, 16th from newspaper and later on from shipping liner.
Shipping liner.
Is it your evidence that your clearing agent did not inform you about the accident?
Yes, later on they informed us over phone.
Could you please tell my lord the name of the person who informed you about the accident on acting on behalf of the clearing agent?
Right now, I cannot remember. I can inform later on the name particularly.
Please come to question 157 that was put to you on 19th March 2025. 157. And your answer there too.
Right now, I cannot remember his name.
Now, question.
Yeah.
What effort have you made during 19th March 2025?
Which question? What? 157.
what you have made,
what effort you have made between 19th March 2025 till date to remember the name of that person.
you are the insurance company. What is the relevancy? You are not the agent. He has not claimed any against the agent. It is an insurance company. Only the question is that whether the materials which was gutted in fire during the sea voyage, the insurance, this goods were covered under the insurance or not.
I can explain.
No, I am telling.
My lord,
Mayor putting the
my lord,
question.
It has got relevance.
Okay, continue.
Subject to correction by your lordship, it has got relevance. Uttarta.
Yes.
No, I have not got the name yet. Next time I will be able to provide.
I suggest to you that you consciously have not disclosed those those other insurance documents, since the same will go against you in the present suit, against the plaintiff company.
No, I don't agree.
I suggest to you that you are consciously suppressing the name of the person from the clearing agent, because no such information was received by you from the clearing agent at all.
No, we received the information. Next time I can tell you the name.
Yes, next.
আচ্ছা exhibit B টা একবার দেবেন? I suggest to you that this document was prepared after 14th June 2018.
No, I don't agree.
একটু জাজের রিপোর্ট ডকুমেন্ট পেজ 7 পেজ 7 থেকে দেখাবো পেজ 7
Separate আছে. This is a separate document I have given.
এটা বোধহয় তুমি দাও
দিয়েছি নিশ্চয়ই.
পেজ 7
পেজ 7 এ একটা মার্ক ফর আইডেন্টিফিকেশন আছে, এটা প্রিন্ট আউট কিছু হবে. মাস্ট বি.
পেজ 7
আমি সেপারেট দিয়েছি নিশ্চয়ই. এই তো মাস্ট বি. দিন প্রিন্ট আউট মার্ক ফর আইডেন্টিফিকেশন. হ্যাঁ, ইয়েস মাস্ট বি.
কি আলাদা করে রয়েছে?
হ্যাঁ.
এটাই বোঝা যাচ্ছে যে কোনো একটা দিন। Do you remember who took? Do you remember when did the plaintiff company obtain this document?
Purchase order.
7 to 33.
Yeah, on 7th June.
What was the reaction?
2018.
What was the reaction of the plaintiff company after receiving this document?
We do not have any reaction because we have LOI for this order long back for total quantity of more than 1,000 ton. So more than 1,000 ton, against which time to time based on that high CCL agreement, for based on high CCL agreement for that particular high CCL agreement for that particular quantity, they are placing order on us.
They are
On
placing
us.
order on us. Go slow, sir.
Is it your evidence that only after obtaining this order on 7th June 2018, the plaintiff company decided to get the subject cargo insured?
No, not like that. During this period, we took initiative for insurance. That is for sure, but not because of this, because already high CCL agreement was done before this date.
Under that alleged high sales agreement, when the defendant number 3 would become liable to make payment of the consideration?
After receipt of the material at the destination port, 15 days from receipt of material at destination port. That was the payment terms with our customer, Tata Steel.
Customer?
Tata Steel.
Tata Steel.
I suggest to you that since the defendant number 3 was to make payment of the consideration of the subject cargo only after receiving the same, it never insisted you to get the cargo insured.
Please repeat.
I suggest to you that since the defendant number 3 was to make payment of the consideration of the subject cargo only after receiving the same, it never insisted you to get the cargo insured.
Agree or disagree? First, say that.
I don't agree this, because as a part of the high CCL agreement, insurance copy to be submitted to them,
Insurance copy to be submitted.
to customer, along with high CCL agreement.
Could you tell, my lord, what would have been the premium of the insurance premium for the insurance had it been done for the entire voyage from Taiwan to Kolkata port?
Tianjin.
Tianjin. Spelling টা বলুন।
TIANJIN. That figure I do not know. I have to get it and then I can get back to you.
I suggest to you.
Just through court. You are taking the insurance of the total voyage or item wise the customers who booked the consignment?
Please repeat, sir.
You are taking the insurance of the total voyage or the item wise which has been booked by the customers?
Basically,
Because the question,
yeah, item wise booked by customers. For this,
yes,
for
but
this case, it was.
my specific question is, you are making the insurance of the total voyage or the item wise insurance which has been booked by the customers, their voyage, their materials.
Things is not clear, because for this consignment total voyage was 48 ton. So
this is only for the one customer?
Yes, this is for only for the one customers.
This voyage was for the only one customer.
Please tell my lord who, on behalf of the plaintiff company, look into the insurance on or insurance of cargo on regular basis.
My secretary Chandrani Bhattacharya. She is looking after.
Was the situation, was the personnel same during 2018, during the year 2018?
Yes, person was same.
It does not appear from your deposition that Ms. Chandrani Bhattacharya was present during the meeting that had allegedly been held on 12th June or 13th June 2018.
Only one thing, my lord. This is exactly the reverse which he has said. Can this suggestion be given?
Which question?
My lord, in cross-examination, my lord.
No. If you put the one question, then you cannot put cross to cross.
No. I'll say question number 5.
Give that.
So this is exactly the reverse the witness has said. That is the only thing. He has not said this. Question number 5. Question number 5. It's a long answer. If we turn over to the 4th page, it starts from the page number 2. At the 4th page, my lord, or she may read. I'm not reading because witness will hear the first 5 lines in from the top. So page 4, first 5-6 lines from the top. This ends.
Yes.
Yes.
It is there. Then why you are putting the other question? Kindly come to, you are having this?
Yes, I have.
Kindly the page number 4.
Yes, my lord, I have seen.
No, don't worry about it. My witness never said this. What you are putting? My witness never said this.
Very well, my lord, let it be struck. May I refrain? I suggest to you that during the meeting allegedly held on 12th June 2018 or 13th June 2018, Ms. Chandrani Bhattacharya never accompanied you.
I don't agree.
Since the plaintiff company used to, during the year 2018, since the plaintiff company used to get number of cargo insured, it was very much aware of the procedure and the documents required. Am I correct?
Yes, you are correct.
Then please tell my lord what was the occasion for you to hold a meeting on 12th June 2018 and again on 13th June 2018 for getting the subject cargo insured.
Because all other consignment in that year, our Chinese we had a transaction with our Chinese principal on CIF basis. So insurance was done by our Chinese producer. In this case, this transaction was on CNF basis, and we are supposed to do the insurance.
I suggest to you that on 12th June 2018, any official of the defendant number 1 never visited your office.
I don't agree because my secretary called them and they visited our office and meeting was done in my room.
Could you tell, my lord, when did you make payment of the premium with regard to the subject insurance?
Next day on 13th June 2018.
Please also, sorry. Please also tell the mode of payment that was opted by the plaintiff company.
That was through online transaction, online that was paid because we have a salary account in HDFC Bank, we have current account in HDFC Bank.
Salary account. We have salary account and
current account
in the
HDFC Bank.
HDFC Bank.
After you got the information of the accident, what step did you take between 14th June 2018 and 26th June 2018?
Actually, we were waiting for the final report from from the shipping company, and this thing, this fire and this incident took time because initially it got fired, then slowly the ship was sink. So the incident started on 14th early morning, but it took time. We were getting information from newspaper and
But it took time. We were getting information from the
from newspaper and from our clearing agent. Then later on, we get final confirmation from shipping liner. Then we submitted the claim letter to HDFC. That's why it took more than 1 month time.
Before you submitted your claim to the insurance company, did you ever inform the insurance company about the accident?
No.
How did the shipping liner inform you about the accident?
They informed us through our Chinese principal or Chinese producer, because shipping line was booked by our Chinese principal. So finally, our Chinese principal confirmed us from shipping line.
Have you disclosed any document to show that it was your Chinese principal who informed you about the accident and that the cargo got destroyed?
Please repeat.
have you disclosed any document to show that it was your Chinese principal who informed you about the accident and that the cargo got destroyed?
Oh, that right now I cannot remember. I have to check.
Yes, next.
প্লিজ একটু এক্সিবিট যেটা দেখাবেন। Please look into this document and tell my lord whether the contents of this document are true and correct.
This document is based on the surveyor deputed by HDFC, and we do not agree the content of this document because this surveyor was deputed by HDFC ergo without taking our consent, and we do not have any information. Later on, we received this letter.
We received this letter.
Yes, next.
আচ্ছা, নেক্সট হচ্ছে এক্সিবিট কে। Please look into the document and tell my lord whether the contents of this document true and correct.
This letter is again that based on the surveyor report. So we do not agree.
My lord, only
Taking this.
Yes. घबरे गए हम देख चुने
Hindi. That is essay in the Hindi. फिर में तुक्का मारना.
My lord,
I heard this. That was the first pronunciation.
तीर में तुक्का मारना.
तीर में तुक्का मारना है. Their letter, I am challenging that letter only. My case is on against that letter only.
my lord, only thing I'm left with a very few questions.
What further?
My lord, this I have to look into this balance sheet
What?
once, and only 10 minutes more I'll require. My lord,
What
Kind-
further
kindly allow-
require?
any day,
What document you are referring?
their balance sheet.
Huh?
Their balance sheet that has been produced today only.
So balance sheet and insurance what?
Okay. But it's a case of damage, and I say that the insurance that
So
has
damage is not with regard to the balance sheet, damage with regard to the
My lord,
materials which was lost in the incident,
my
fire
lord,
incident.
my entire case is that the insurance that is being claimed to have been done, it's a case of a fraud. So, my lord, kindly allow me in only 10 days, 10 minutes time, tomorrow, day after tomorrow, any day, my lord, permit.
Plaintiff is present. Cross-examination resumed. Full stop. After some part of the cross-examination, the counsel for the defendant waits for time. Accordingly, the cross-examination is deferred. Full stop. The defendant, by a letter dated 8th of September 2025, requested the learned advocate on record of the plaintiff for production of the following documents. 1, 2, 3, 4. Following document. On the basis of on receipt of the said letter, the plaintiff has produced the documents mentioned in serial number 3 and 4. As regard the document mentioned in serial number 1 and 2, it is submitted that as regard the document number 1, serial number 1, it is submitted that the defendant has asked for the documents of all consignments of the client of the plaintiff, which